And we are recording. It is 4:34 p.m. Would you like to announce the meeting?
Sure. This is the Sunshine Ordinance Task Force Compliance and Amendments Committee meeting. We're meeting on January 26th at 4:30 p.m. And if Cheryl, we'll call the meeting to order, and Cheryl, if you could read the remote access information, please.
Okay. Remote access to information and participation. In accordance with Governor Newsom's Executive Order N3320, declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London and Breed's proclamation declaring a local emergency issued on January 25, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health Officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment via video conference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. All comments received will be made a part of the official record. Sunshine Task Force agendas and their associated documents are available at sfbos.org/sunshine. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on current situation as it affects the legislative process.
Thank you. And then as for meeting decorum, any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and or menacing behavior may be asked to leave. Please call the first item.
Item number 1, call to order, roll call, and agenda changes. So let's do roll call. We have called the meeting. Bruce Wolf.
Here.
Bruce Wolf present. Jennifer Wong.
Here.
Jennifer Wong present. Chair Lila Hood.
Present.
Chair Lila Hood present. We have a quorum. I am not aware of any agenda changes unless you are.
Just one thing, and Cheryl, I am sorry that I did not notice this earlier. There is what looks like a typo. It looks like
19047.
Yes, it looks like.
Yes, I know. I saw that.
Yeah.
And it should be the office of the mayor.
Right, and I believe the date is. I think that it looks like that might have been copied from a different file.
Oh. All right. Well, I'll check on it.
Yeah, everything is correct within the documents associated with it. But yeah.
All right. All right. So shall I read item number 2?
Yes, please.
Item number 2, approval of the October 27, 2020, November 24, 2020, and December 22nd, 2020 Compliance and Amendments Committee meeting minutes. There were changes suggested by a participant, Mr. Hilliard, on the October 27 minutes, which I corrected. And until those were corrected, it was decided that the November 24th minutes would not be addressed. And so December 22nd are the meeting minutes that we would normally address in a case like this, a meeting like this. Those were last month's meetings.
Thank you. Members, any changes from us for the minutes?
No.
Nope. Move to approve the minutes with the proposed changes.
Do we have a second?
I'll second that.
Okay, let's open it up for public comment. Any members of the public wishing to comment on the October, November, or December minutes?
Hello.
Yes.
Are you taking public comment on the minutes?
That's what I'm asking for right now. Cheryl, are you ready with the timer?
Yes, I am. Is this Mr. Warfield?
Yes, it is.
Okay. Go ahead, sir.
This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com or by mail, especially if you care more about privacy, P.O. Box 170544, San Francisco, California 94117. I was trying to get to speak and was having difficulty because your instructions on your agenda do not indicate how to make oneself known. It's only that I know how to do it from other meetings that I know to press *3, which didn't seem to do anything until I tried *6 from another previous experience. And then, you know, I started to get unmuted, you're unmuted, and so on. With respect to the minutes, I'm glad that the one that I saw looked like it had pretty extensive descriptive material, and especially it wasn't clear to me there was a question portion of the first minutes, the earliest minutes, I guess, and I appreciated very much that there was a long explanation given about apparently a question that came up about the meaning of the law and how the law is applied and so on with respect to policy bodies and other kinds of policy, passive meeting bodies, and so on and so forth. I think that would be terrific. I didn't understand whether that was an agenda item, but in any case, I think that it could be very valuable for the Sunshine Task Force to have question time for the public as well as its own members, and also an opportunity for additional clarifications and explanations of what the law says and what people's rights are. Thanks very much.
Thank you. Is there any additional public comment on the minutes?
Anonymous, please.
One moment. Cheryl, are you ready with the timer?
Not yet. Go ahead, sir.
Which of us is starting?
Yeah.
Anonymous,
go
you
ahead.
go first.
Okay. All right. I did have this is anonymous. I did have a few corrections to suggest. One, they're all on December 22nd. So under file number 20074, it says anonymous noted that not all records received are responses. What I noted is that not all responsive records are exempt. So that's one correction. The second correction is that under file 20066, it says anonymous stated that his request is for audio recordings under Penal Code 832.7b6. That should instead say anonymous stated that his request is for audio recordings and records withheld under Penal Code 832.7b6, which is very different. And the third correction was...
Hang on a second. What was that penal code again?
Sure. So the second correction was that under file number 20066, the current statement is anonymous stated that his request is for audio recordings under Penal Code 832.7b6. And that should be corrected to anonymous stated that his request is for audio recordings and records withheld under Penal Code 832.7b6. And the final correction is under file number 19144, where it says anonymous stated that the respondent is willing to provide a transcript instead of a body cam footage with redactions. It should say anonymous stated that the respondent is willing to provide a transcript instead of recordings with redactions and not body cam footage. Thank you very much.
Thank you. I believe there was a third speaker wishing to make public comment. Is there someone else there?
Yes, Chair LaHood, this is Winship Hillier. I'd like to make a public comment.
One moment, please. Cheryl, are you ready with the timer?
Go ahead, sir.
Thank you, Cheryl. I spoke during item number 4 on October 27th, and I spoke from a written transcript. And after the meeting, I sent the transcript to Ms. Leger, and then when the minutes came out, I sent an email asking for corrections, and I also spoke regarding their approval at the November meeting. and they were continued to the December meeting, and but they didn't come up then, and they come before you now. I asked that the minutes not be approved as they are, as they appear. My the hearing summary still it substantially misrepresents what I said. Puts words in my mouth that I didn't say. It doesn't make sense. It substantially changes the meaning of what I said. It takes away the entire force of the argument. And so from the last speaker, I understand it would be helpful for you if I actually spelled out what the change should be. So I'm going to try and do that from memory. I've got the minutes to be approved on my phone right here. It says at the end of the third paragraph on item number 4, the last sentence says, second, due to Proposition B, the SOTF would need to provide evidence of positions, offices, vacancies, or seats for a member physically incapable of attending meetings in person. And that sentence should say, second, due to Proposition B, the SOTF would need to provide evidence of positions, offices, vacancies, or seats being incapable of attending meetings in person. Back to you, Madam LaHood.
Thank you. Do we have any other members of the public wishing to make public comment on the minutes? Seeing none, I see Member Wolf has a question.
Yeah, I'm just wondering, instead of for these corrections, if they try and get folks to, or have folks try to recall what was said, all our meetings are recorded. So I think if we, just go back to the recordings and if we can just get the context of what was incorrect, we can go back and listen to that portion of the playback and make correction of the of what was said. The reason why I say this is because we have to corroborate what is actually on the record. We can't just add things that are being introduced by recollection. So that's also why the ordinance allows for people to provide a written testimony of up to 120 words, so that lots of times that's what people do. They'll do a verbal testimony, and then they'll submit it in writing for the record. So so there's no mistakes that can or misunderstandings or interpretations, that kind of thing. So I just wanted to notate that in general, that we can accept the corrections what people are bringing to us, but they should be corroborated with the audio, the playback from our meeting. Thank you.
Okay, so and forgive me, I was listening, but I didn't make note of that. Cheryl, can you tell me which was it, the October and the November, or October and December that where changes were requested?
Mr. Hillier sent a 2.5-page testimony of what he said at the meeting, and so I summarized it the best I could. Mm-hmm. And I can't obviously put the whole testimony in the minutes for obvious reasons. So those minutes are from October. And he had sent corrections to me, which I applied to the minutes when I was uploading everything. Mm-hmm. So those were written corrections that he asked me to make, and I made them. So.
Okay, so that's for the October. So Mr. Hillier was referring to the October minutes.
Correct.
And Anonymous was referring to which month?
I believe it was November.
November. And we've had no request for December. Nobody had any issues with December. Is that correct?
I guess not.
Okay.
Nobody said anything for December.
No one said anything for December.
But as far as Anonymous having sent me corrections for November, I would have applied them, but I don't recall getting them. And I did look to see if there were corrections. Mm-hmm. But if he did, and Anonymous says that he did, then I just ask that he send them again, and I will correct the November minutes.
Okay. It sounded like, and members tell me what you think of this, it sounded like the change for the October minutes, because Cheryl had already made the other substantive changes, it sounded like there was a minor change with one sentence.
For Mr. Hilliard, for yes. Mr. Hilliard's testimony?
Yeah.
Okay. Yeah, I mean, I'll listen to the tape to hear what it is he thinks he said, but I also have the his email that said what the changes were, and that's what I went by.
Okay. Members, how do you think? How would you like for us to handle this?
So I think, well, you know, what's hard is that the corrections on the minutes really needs to be corroborated with what is actually said at the meeting. If somebody did provide a written testimony, we can only include 120 words. That's the way the law reads. Okay, so you know, if there are specific, if it becomes very extensive, then I would suggest that the playback be, as I mentioned before, the playback be reviewed, and that section of the minutes be rewritten, and then brought back for you know, to be reaffirmed. Just to be sure, also, it'd probably be good to, you know, to work with the person who made that testimony to make sure that it's being captured correctly. I mean, you know, sometimes how it's said, you know, can be interpreted in any number of ways, so the context could be lost, you know, in that way. We just want to factually reflect by paraphrasing what is being said, and not try to interpret the intent or the meaning of what somebody is trying to say, so to speak. If it gets lost in translation, then let's correct the translation and make it right. I think it's as simple as that.
And I think your point being specifically what was said in that meeting, not a general summary of the individual's perspective on this issue, which is a completely different thing. Correct. Okay. In that case, we had a motion and a second. Would the motioner, would you like to revise the motion?
I would say, I guess at this point, if it's still drastically, it seems to be that there's still drastically incorrect. So I would say
the October one sounded, sorry.
It's not. I'm sorry.
The October one sounded like a minor adjustment.
Right. Yes, that's right. So the October one. Oh, hold on a second. Make sure I'm looking at the right thing here.
May I speak briefly? My name is Wayne Shapilier.
All right. So the October, the October minutes. We can accept those with the minor changes. The one. So which one is it that Mr. Hilliard was? concerned about the 24th.
No,
Should-
his testimony was in October.
Oh, it was in October. Okay.
Hmm.
So let's hold back the October minutes. Let's
Okay.
get those corrected. We'll bring them back at our next meeting. And then November and December we can move forward on.
Well, November also has requested corrections from Anonymous.
Oh, right. So we can if I'm okay with those changes.
Meaning just say we motioning to enter those changes as specified and approve November.
Well, here's the thing. Let's take each
Okay.
set of minutes separately because there are issues with each one independently. So I would just to move to continue approval of the October 27th, 2020 minutes to redo Mr. Hilliard's testimony. That would be the first one.
Okay. Would the second on that accept that modification?
Yes.
Okay.
Okay. So then let's vote on that so we can get it out of the way.
Do we need to reopen it for public comment because we've changed it?
Well, all we did was we're just continuing it. So
Okay,
to
we're
make
continuing.
corrections. I don't, we've heard unless public comment was not finished. I don't know. It's up to you. You want to reopen it or not?
I don't think we need to hear from the people who spoke before, but if there's anyone else who would like to make public comment on this abbreviated, or we're breaking the initial motion into pieces. Anyone who has not yet made public comment, would you like to make public comment on this motion? Seeing none, let's please call roll.
The motion is to continue October 27, 2020 minutes, the next meeting, pending the corrections.
Hang on. Member Wolf?
Aye.
Member Wolf, aye. Member Wong?
Aye.
Member Wong, aye. Chair LaHood?
Aye.
The motion to continue the October 2020 meeting minutes passes.
Okay, great.
Thank you.
So now the second set of minutes, we have corrections that are being requested by Anonymous. Did we finish public comment on that one? Let's get all of it.
We
Well,
finished
let's have-
public comment on the first motion that we've done. And
Okay.
we've had public comment in the public comment section.
Okay.
So do we have a second on the motion to continue the November minutes?
Well, do we need to continue the November minutes? That's my question to you. Do we need to?
Changes
Or-
have been requested.
Okay. Can we, is there a need to research those questions? Or can we accept those changes? Are they simple in context or are they extensive?
I'd like to ask Cheryl, it sounded like it was
Pretty simple, actually. It's just
Okay.
a matter of a couple of words. So I
okay.
can come back and listen to the tape. I mean, I took notes, but I also took notes on the section of the tape it was, so I can go back and listen because he was specific about a couple of words that were not in the minutes. So I will go back and listen to the tape. So I suggest we do a motion to approve the November minutes and with the requested
With those
changes.
corrections made.
Okay, so I'll move to approve the November 24th, 2020 minutes, pending, to accept the corrections pending corroboration with the audio. If there are any concerns about that thereafter, Cheryl, then bring it back to our next CAC meeting. Okay?
Okay. Okay, so you made the motion. Who's going to second this?
This is Member Wong. I'll second.
Is there any comment on this from anyone who did not previously comment on the November minutes?
Yes, Anonymous. I did not comment on the November minutes, actually.
Okay.
It's not the November minutes I have a comment. I don't have any
All
else.
right, that's why we
Anonymous,
need to take these one at a time.
Okay.
Okay.
Anonymous, you may begin.
So the comment is that I did not say a comment about the November minutes. My comments were all about the December minutes. So I guess I haven't spoken on November minutes. I have nothing to say on the November minutes. So I'd ask that you correct the motion to be December. Thank you.
Okay.
I have something to say.
Please go ahead.
Hang on.
Hi,
Peter,
Peter.
hello, just hang on a second. Go ahead.
it's Peter Warfield, Executive Director of Library Users Association. I commented on the first minutes and in particular a particular item, which I thought was well done. I didn't comment on the others. I appreciate the chairs asking for public comment on the changes. It seems to me that if the changes, particularly if they were inaccurate or misleading or wrong, one certainly would want to comment on a motion to make changes that a person was not able to comment on. So I'm disappointed that comments were reserved for those who hadn't previously commented after there had been changes agreed to. It's also not clear to me who is supposed to provide the audio for which there should be a check, and it wasn't clear whether, for example, the administrator would do that or if the person requesting corrections should do that. I'd appreciate if you might clarify that. And then Member Bruce and Bruce Wolf and Chair elsewhere mentioned 120 words, and if I'm not mistaken, if we're talking about the member of the public provided summaries, which was a long battle previously, I believe it's 150 words. A person can submit up to 150 words summarizing what they said at a meeting, and that has to be included in the minutes verbatim as they provided. Presumably it's accurate. So if there is a change, I'd certainly like to know, for as far as I know, it's always been 150 words. Thanks very much.
Thank you. Is there any additional public comment? Seeing none, I would like for us to respond to these. Yes, I do believe it is 150 words. And there was another question, and maybe Bruce has his hand raised, so please go ahead.
Yeah, so that was my Freudian slip, because I was working on affordable housing around 120% AMI, so I had 120 in my head. So thank you for that correction. And just also, this is all directed at the administrator to listen, to make the corrections. So it's always to have the administrator review the audio. That's all. Thank you.
Thank you.
But to be clear, the audio is also available on our website for anyone's reference. If any members of the public would like to go back and listen to the audio for previous meetings, it is available there. So it seems as though we got our months flipped, and in fact, there are no changes to the November minutes, but changes to the December minutes. Would you like to change your motion regarding the November minutes?
Yes, I would adjust the motion to approve the November 24th, 2020 minutes with no changes or edits.
I'll accept those adjustments.
Okay. And since there were previously not comments on the November minutes and it was our error, I'm going to say let's call roll on the November minutes and then we will move on to the December minutes.
Member Wolf?
Aye.
Member Wolf, aye. Member Wong?
Aye.
Member Wong, aye. Chair LaHood?
Aye.
The motion to approve the the November minutes passes.
Thank you. Let's move on to the December minutes. So the third modification to the original motion.
Let's just ask if there are any changes or adjustments, and also from the public, and that way we can include all of it into the motion, incorporate into the motion.
Members of the public, understanding that the earlier comments from Anonymous were regarding the December minutes. Is any other members of the public wishing to comment on the December minutes? Seeing none, let's please have a motion.
So I'll move to accept the corrections from a member of the public, Anonymous, for the minutes, pending corroboration with the audio.
I will second that.
Okay. Is there any public comment on this motion? Seeing none, please call roll. And for anyone on the phone, please make sure that you're muted when you're not speaking. I heard some background noise. It's *6 to both mute and *6 to unmute.
Member Wolf?
Aye.
Member Wolf, aye. Member Wong?
Aye.
Member Wong, aye. Chair LaHood?
Aye.
Chair LaHood, aye. The motion to accept the corrections from Anonymous for the December minutes, which will be corroborated with the audio, passes.
Thank you, Cheryl. And one last thing, since we were discussing the 150-word statements, if members of the public would like specific wording included, they may submit specific wording. Otherwise, please know that the minutes are a summary of what is discussed in the meetings and is not intended to be verbatim. Please call the next item.
Thank you, Chair LaHood. Item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda.
Okay. Do we have any members of the public wishing to make public comment?
Yes. Yes, if you can hear me.
One moment, please. Cheryl, whenever you're ready, please give the signal.
Go ahead, sir.
This is Peter Warfield. Can you hear me?
Yes.
Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com or at P.O. Box 170544, San Francisco, California 94117. I say these things in lieu of actually being in a meeting where somebody might walk up to us or we might walk up to somebody and say, great job, or we're interested in something similar. We have a long history with Sunshine, and I don't think that I've met or seen two of the folks. Bruce Wolf, of course, also has a long history, and we've certainly seen each other at meetings and so on. There's a couple of things that are a concern and also long-range concern. I don't see from the body that should be exemplary, I don't see information about how to mute and unmute, thereby indicating presumably that you're interested in speaking. And *6 would be helpful. I appreciate when the chair said what to do, mute and unmute, but I think that should be in the agenda description. And I'm also curious what you see with respect to the information about the caller. Sometimes it seems partial phone numbers are visible. And also who can see that? I guess you folks can see each other. I'm not clear on that. And presumably you can see something about the caller. In any case, I'm curious about that. And I was completely unclear about what the change was to 19047. There was some kind of an error. It was copied from a different file. You may know what you're talking about, but members of the public, especially on the phone, are going to have a lot of trouble understanding. Can I get a 30-second warning, by the way? My timer went off.
Oh, you've got 1 minute left.
Okay, thank you. At the Discussion and Rules Committee yesterday, there were several points made by Supervisor Peskin, who talked about some of the problems that face the Sunshine Ordinance Task Force. He referred to a backlog, which I think is certainly important, in fact, catastrophic for open government.
30 seconds.
Thank you. He talked about inadequate staffing, and he's certainly right about that as well. We would certainly like to know what the task force is doing about such problems if it sees those, and certainly to see what the supervisors might do to help with that. There are also problems with procedures and, of course, a long-standing problem with enforcement. But I think this would be a good time, especially because so much has changed under COVID. I think this would be an important and valuable time to go over some of the basics and review those. Thank you.
Thank you. Is there any additional public comment on matters not on today's agenda?
Anonymous, please.
1 moment. I heard anonymous, and then I heard someone else after that. Is there another person?
Yeah, my name is Winship Hillier. I'd like to comment.
Okay. I heard anonymous first, and then Mr. Hillier, you'll be after that. Cheryl, please give the signal when you're ready.
Anonymous, go ahead.
Thank you very much. I agree strongly with Mr. Warfield's prior comments. I think the Mayor's Office on Disability, I don't know the full name of that agency, does a great job. They actually tell exactly all the different ways you can speak or unmute yourself, etc. And so I'd suggest that not only do you do that here, but you actually suggest that in order to improve public access to meetings, especially for people who may not know all the ways of using the particular computer system involved, that every agency that held public meetings should do that. And with regards to staffing, I very much hope that that you get more staff. There is no reason that this very important function of holding the city officials accountable, and I know that weighs directly on Ms. Leger, and I know because I'm a big part of that backlog, but that doesn't mean you don't hold the city accountable. And that's sometimes what it seems like what the Board of Supervisors or maybe even some people in the public prefer. That, oh, well, there's so many members of the city agencies who don't follow the law. Well, let's just ignore it because there's so many of them. That's not the right solution. There are various solutions to do that kind of more systematically, but the right solution isn't to ignore it. But more importantly, I wanted to say something very happy. The Police Commission 2 weeks ago decided to discuss the issue I brought to this committee last month in December about their agency, the DPA and the SFPD, not justifying the records, their use of Penal Code 82.7b6, which is the public interest balancing test, not keying their redactions, et cetera, et cetera. I was pleasantly surprised that the commissioners instantly actually started investigating what I brought to them. And right now, the DPA and the police department are in progress of writing written letters about what exactly they are going to do and how they're going to comply. But see, none of this happened until you held a hearing. I brought these issues to the city's attention in late 2019. Why does it only happen once you hold a hearing and the police commission holds its own hearing? Why only then does anyone listen? They should always listen. The law is there. It must always be complied with every member of the city family. Thank you very much.
Thank you. I believe we have a third public comment. When Cheryl's ready with the timer, she'll give you the signal.
Go ahead, Mr. Hillier.
Thank you, Madam Clerk. I just wanted to clear up something. I heard a member of the public saying that you are bound to provide allow members of the public to submit 150-word summaries of their testimony. And I would like to clarify that comes from San Francisco Admin Code Section 15.16. It only applies to charter boards and commissions. And as far as I know, the SOTF was created by the administrative code. It was created by ordinance, not by charter. Therefore, the 150-word summary requirement does not apply to the SOTF. Back to you, Madam Chair.
Thank you. Would any members of the task force like to comment, or members of the committee like to comment on that? Member Wolf, I see your hand raised.
Yes. If we want to take the public commenters' notation on that, then the task force does not have to accept any written public testimony.
Okay. Do we have any additional public comment on matters not on today's agenda?
Dente Teresa?
Yes. One moment, please. We hear you. Cheryl's going to get the timer ready, and she will let you know when you can begin.
Go ahead, Mr. Chidesi.
Hi, this is Dente Teresa again. Sunshine Task Force members, I'm a little bit taken aback from what was just said by the chair, saying that you're not going to now, it seems like you're erring on the side of that you don't need to take written summaries at all. What I understood when I first came to Sunshine Task Force was that you tried to be the leader or the example for the whole city family, as you say, for open meetings and open records and just transparency in general. What I found is that the transparency has gone away. There is for example, for the city attorney memos, the Sunshine Task Force had opined, saying that basically that is the only department within the city family that actually has that openly available to the public. The memo itself being open to the public to see what is going back and forth in terms of opinions of the city attorney assigned to the Sunshine Task Force and the task force members' questions. That has gone away. Now it seems that summaries might be going away. My own experience has shown that delays and other tactics used by the city attorney that works for the Sunshine Task Force, I believe, to delay people's hearings, people's rightfully deserved due process. Due process has gone out the window at the Sunshine Task Force, and
30 seconds, sir.
And it's lamentable. That's it. Thank you.
Thank you. I see. I'm going to make one last call for public comment. Is there any additional public comment on matters not on today's agenda? Seeing none, I see Member Wolf has a hand raised. Please go ahead.
Yeah, my comment about that, what's very key in my comment was I said if that were the case, okay? I was just calling more or less the public commenter who referred to the section 6716.16 with regards to the task force not being enumerated in the charter. I would not venture that the task force would not follow the ordinance to the T. The ordinance, the Sunshine Ordinance Task Force, this chair, previous chairs, all the previous chairs back to the beginning, all the previous iterations of the task force has always followed the ordinance as if it was a policy body by choice. And it's not clear as to what the actual nature or classification of the task force is. Is it a policy body, or is it a passive meeting body? Because those are the only two types of meeting bodies described in the ordinance itself. So I would just assure the public that the Sunshine Ordinance Task Force takes the ordinance very seriously and will not abridge what applies to a regular policy body for itself.
Thank you. One last thing, there was an earlier question about what appears, and I would like to let members of the public know that when you're calling in by phone, all we see is +1, the first number of your area code, and the last two numbers of your phone number. Everything else is starred out in the middle. We don't see names or any other identifying information. Those of us on the committee and city staff, we can see names, and if people have the video turned on, we see their video, just so you know what we are seeing and what we are not seeing. We do appreciate the suggestion about adding *6 for muting and unmuting yourself into the instructions. I think that would be helpful. It was not clear to me that people did not know that, and I think that would be an easy thing for us to add. Please call the next item.
Item number 4, file number 19044, complaint filed by Anonymous against Dennis Herrera in the Office of the City Attorney, excuse me, for allegedly violating Administrative Code Section 6721, 26, and 27, Government Code Sections 6253, 6253.9, 6255, by failing to respond to a public records request in a timely and/or complete manner.
Okay, and we have an order of determination on this, so this is for compliance. Are the petitioner and respondent here today?
Petitioner is present.
Do we have the, sorry, go ahead. I think I spoke over, is the respondent here?
This is John Cote with the City Attorney's Office.
Thank you. Just to verify, again, this is for compliance. This is an issue that is chiefly about metadata. We did have a finding from the task force in October 2019 that there was a failing to provide records in a timely or complete manner, keeping of withholdings to a minimum, and need for justifying the withholding of records. Petitioner, has the respondent complied with our order of determination?
That's you. I want to correct. I don't know if it's a point of order or whatever, but that's not correct. It's not October 2019. It was January 2020. That's when you made the decision.
Forgive me. I was reading the wrong date. Has the and I think that's where Yeah, okay, yes. I'm sorry, I was reading from the wrong summary. Has the respondent complied with our order of determination?
I believe they have partially complied. So there were two. Am I allowed to explain? Is there a timer? I don't know how this works actually.
I'm that was my question. At this point, members, do we have questions for the petitioner and the respondent?
Well, I would just pose the question you just asked and just have them answer it. I think we're beyond the timing of the timing. We're trying to just get clarity of what's happening now. We're asking and engaging the parties at this point directly. So just let it go.
Okay.
Just let the conversation happen. Thank you.
Please go ahead.
Okay, sure. So I do want to refresh the memory of not all of you were here. So this is an April 2019 request. I'm going to request for the entire of two emails, including email headers, one they sent, the one they received. You held hearings from October 2019 to January 2020. You made the order determination you just stated. On January 20th of 2021, that's 1 year later, they produced one of the two emails. I believe it's pretty close to minimally redacted. On January 25th, which is yesterday, they produced the second email. There's no dispute about the second email. It's not in your record because it was after the deadline. They're going to give you, I think, a big argument why they should have never done this, et cetera, and why they don't have to, but this is not an appeal hearing and it's not a reconsideration hearing. The only issue outstanding is there's one field that I've asked the Department of Technology to add to the green list, and the second is that there is they claimed at the time of the hearing evidence code 1040 as their justification for why they withheld the metadata. They are now claiming 4 total justifications: 6254.19, information security risk, which I actually agree with, evidence code 1040, government code 6255, public interest balancing test, and a claim that it's not a public record at all. And I'm not going to argue these issues. I believe they simply have, in order to comply, they just sort of tell you in a key, right, a redaction by footnote or other clear reference, they just sort of tell you which parts of the record are which of these 4 things. So I think if they provide that key, and I don't disagree with that key, and some things I might agree with them, then we're done with this complaint. But I don't think they've provided that key so far. So that's, I think, all that's outstanding on that first email, a key of the redaction. Thank you very much.
Thank you. Mr. Cote, would you like to present your side of the situation and tell us, have you been able to provide a key, or are you in the process of compiling a key that would have this information?
Sorry to interrupt.
Sorry.
This is Member Wong. Sorry, Cheryl, do you mind muting yourself, please? Thank you.
Mr. Cote, please proceed.
Thank you, Chair LaHood. We are not in the process of producing a redaction key because one is not warranted in this situation. We lay out 4 exemptions, and these 4 exemptions all apply to each redaction. We have explained that to Anonymous in an email response, and so that is the explanation. There's no need for a key.
So there's no distinction. All 4 exemptions apply to every redaction in the documents provided.
That's correct.
Members, do we have any questions for the petitioner or the respondent?
I'm just wondering how that is in compliance with the ordinance, when the ordinance requires a keyed log for each redaction.
I don't believe the ordinance uses the term a keyed log for each redaction. It says you have to give justifications for each redaction, and we did. There are 4 bases for the redaction, and I'm happy to go through those 4 with the committee if that's helpful. And those 4 bases apply to each redaction. So the key would say the same thing over and over again for the number of redactions that are in the document.
Thank you.
Certainly.
Members, how would we like to proceed? Would we like additional information from the petitioner? Actually, I'd like to ask the petitioner, does this response make sense to you?
No, it doesn't, because, and I told them that in writing. Unfortunately, they gave me this response a few minutes before the deadline for your deadline. So my argument is it's impossible for something to be, I'll give you an example. It's impossible for a particular piece of information to be a threat to the network security of the city's computer systems, and it's very specific. It's not about threat to other people, and also not about the conduct of public business. I don't believe, first of all, that's even possible. The same information could be under both exemptions. Second, it's not possible that they can claim that some of this information was received in confidence, and you can read through Evidence Code 1040B2 and A, which is what they're using. That's the official information privilege, because I'm the one who sent them the email. So, and it's about a public record, so it's not received in confidence, and it is not as Evidence Code 1040 requires. They would have to justify a harm to the interests of justice, and so we can go through here and debate all of this, but I think I don't think it's possible. And finally, the exemption where they claim, oh, it's just not a public record at all. We already discussed this at the IT committee. It is a public record because it is part of a public record. A word is not a public record or not a public record. The entire email is a public record or not a public record. That was the first argument. The second argument is that I am not completely clear about this argument, which is they're saying, well, some of that information is not sufficiently about the conduct of public business. But that's not how the law works for what the definition of public record is. The courts have vastly expanded the meaning of the word public record, and I cited this in my email response, where it's basically anything that's not purely personal is a public record, and it goes in detail saying it's on any kind of record keeping form ever invented, ever could be invented. So I do agree except for one specific field on the 6254.19 justification, and because of COVID, they're using 6255 also, so I'm not going to dispute that, I don't care. But I do dispute that they claim that this information was, quote, received in confidence by a city employee, and then, quote, it's the whole public interest balancing test, but also in the interest of justice. You can read through Evidence Code 1040 if you would like to. And I would also dispute that they can claim, well, this word is not a public record, even though the whole record is. As you, the task force, said, the metadata is part and parcel of the whole record. And the whole record is about the conduct of public business, which is why they have to minimally redact it. So I don't know what, I hope that's enough of an explanation. I didn't realize, okay, now I understand. They're saying, okay, they're right. They don't have to give me a better key if it's true that all four justifications apply to every single redaction, but I'm pretty certain that only the
Did we lose our speaker? Anonymous? Anonymous, if you're speaking, we don't hear you.
Hello?
Hello, yes, we lost you for the past minute.
Hello?
Hello?
Did you hear what I said? By the way, you're having some technical issue. Your conference call number keeps calling me. I don't know if someone's pressing some button, but the conference call number is calling me while I'm speaking. So
we did not hear what you said for the last minute.
Okay. Okay, I'll just try to leave. Do you know what you heard at the very end? So I don't.
We heard you saying that that the 4 justifications could not apply to all of the instances, primarily because you were the one who initially sent the email and you didn't send it in confidence, and so that justification cannot be given for not sending it back to you.
Okay. I'll carry on from there then. Yes, that's the reason why Evidence Code 1040, which is the official information privilege, could not apply to much of in there. That requires 2 things. One, that they show that the city employee received the information in confidence, and 2, they must show that producing that information would violate a state or federal law. That's not applicable. Or the second half option is showing that the public interest in non-disclosure I believe would outweigh the public interest in disclosure in the interests of justice. So I don't think they can meet any of this. I don't think that the information was received in confidence. And 2, I don't believe that they can show a harm to the interest of justice. There's no issue about justice involved here. Second, then the other one they argue is that, it's not a public record at all. We already discussed this. I mean, we can rediscuss this again. But the argument that the SOTF itself stated was the metadata is part and parcel of the record, and since the record is about the conduct of public business, so is the metadata. They make a second argument that, you can go like piece by piece and say, well, this is a public record, this word is a public record, and this other word is not a public record. That's not a record. Like, the word is not a record. The whole record is a record. The other one they've cited is public interest balancing test. I just don't care about disputing that one because COVID is around, so why even bother disputing that one? So yeah, I don't think that Evidence Code 1040 and not a public record at all apply to almost all, if any, of these redactions, and that's what I still dispute. I have, by the way, gotten the others to kind of do this piecing and give a key. I don't know why the city attorney's office isn't, like, I don't know if their argument is that every word I can tell you, the IP address of a city system is about the conduct of public business. However, it's exempt because it's under 6254.19, but it is not a public record. Anyway, I don't know more to say about that. So.
Thank you. Member Wolf.
So I just want to get some clarity from the petitioner anonymous. You said at the opening of your testimony here that there wasn't any additional issues that you would find for any further action to be taken on this, and that you more or less have received everything that you asked for. Did I misunderstand that?
There's one field that I am still asking. It is the field you guys discussed at the very, very first hearing. It's the field that tells you whether or not the email was spoofed, not the authentication material, but whether or not it was spoofed. So I'm still, I've asked DT to add that to the green list so they can disclose it.
All right. Is there any dispute about receiving that field, that information?
Is that a question for me or for them?
For you. Have you received
I don't know.
any?
I only got that record right at the deadline, so I don't know yet. If they're happy to disclose it, we can hopefully be done with this today.
All right. So, okay. So one thing I want us to just be clear on here, that if records were to be ordered to be produced at the time of the order determination, then it's only those records that are to be produced, not anything. There's anything in addition, just because we're talking about the same item. So if there were metadata items that were presented during the hearing, and those are the ones that were the order was based on, then it's those items. I just want to be clear that we're not talking about additional items thereafter the order determination was made. Can I get a confirmation on that from you, petitioner?
Yes, this is a line in the original email that was fully blacked out at the time that you determined that it was 6726, not fully withheld. Correct. I'm not asking for something new or some other. Yeah.
Okay. Okay, great. Okay, so the question I have then is, shall we continue this item for monitoring pending the review by the petitioner of now this late-breaking additional or the final piece of information that they were asking for? And then and then we might want to ask the petitioner if it's necessary at this point.
Yeah, I would ask petitioner, based on what you were, do you need time to review that and for us to do additional monitoring, or are you satisfied with what you have received, although it was delivered at the last minute?
To be clear, that has not yet been delivered, that last field. So if you can just ask them, and Mr. Cote can tell you that if the cybersecurity professionals agree, they will disclose it, and just orally they agree, I'm happy to put an end to this. Yes.
Mr. Cote, will your IT advisors permit this information to be released?
So our redactions to date have been done in alignment with the Department of Technology and the fields that they have determined are not a security risk. If they make a similar determination about this particular field that Anonymous is now asking for, and to be clear, they have not. The Department of Technology has not made that determination yet, as far as my understanding is. I think we would be consistent with what we have done previously, and if the Department of Technology and our own IT experts confirm that that field does not pose a cybersecurity risk, then we would not redact it. As long as I should be clear. As long as there is not any other exemption that applies to that specific field.
Petitioner, does that?
Actually, if I may, Chair LaHood, the other thing is, I'm more than happy to address the question of how these four exemptions apply to all redactions. I don't know if the task force needs that information at this point, but I'm certainly happy to provide it.
You know what? We would love to hear that from you. Yes, please go ahead.
Certainly. All right. So there are four exemptions that we cite. The first is Government Code 6254.19, which is that the information poses a cybersecurity risk. That clearly applies to every redaction. We redacted based on DT's guidance of what comprised the security risk. So that clearly applies to all. And DT, I should note, has worked with Anonymous on this issue and has agreed that the section 6254.19, that section applies to all of the redacted information, except this one little piece that he has now raised questions about, this one field. Second, Cal Government Code 6252E. So this is another alternative basis to withhold. It applies to all of the redacted excerpts because those excerpts are not substantively related to any public business and therefore not a public record. Keep in mind that this is metadata. It is not written by any city employee. The sender isn't writing it either. Microsoft is creating it, unbeknownst to most people sending or receiving such emails. The third basis is Cal Evidence Code Section 1040, also known as the Official Information Privilege. And that is another basis to withhold the portions that are exempt. So under the Official Information Privilege, if info is normally kept confidential, you can withhold it if the interests in non-disclosure clearly outweigh the interests in disclosure. So we don't normally disclose this metadata information. It's sensitive. It has things like IP addresses, etc. We're only asserting official info privilege on the things that the Department of Technology has already said are sensitive. And then finally, Government Code Section 6255 also clearly applies That's the balancing test in effect because of the pandemic. So that clearly applies to every redaction as well. So we gave proper justifications for each of these redactions. The thing to keep is all 4 bases apply to all redactions, and keep in mind that all we needed to provide was 1 exemption, and we provided 4 because all 4 apply. And the bottom line is this redacted info is exempt from disclosure. You have to justify your withholding, and we justified it.
Thank you.
Certainly.
Members, how would we like to proceed? Member Wolf, please.
Okay, so a few things. I'd like to move on from this case with regards to additional monitoring, but I have a few things that I want to say with regards to this. First of all, I don't necessarily accept all the justifications that the respondent continues to put out, and the reason why is this has been a very difficult area for the Sunshine Task Force, not having the ability to see documents in camera. A respondent can cite a justification, but they have to provide specific reason based upon the actual document that is being withheld as to why it's being withheld. For instance, if they are going to cite the evidence code and it is an investigation that is currently in process and has not been closed yet, verification that the file exists can be had without revealing any information about what's in the file. Just the fact that that investigation exists. But to come in and say, well, I'm not going to give you these records because they're under, investigation, and I'm going to cite evidence code 1040, that's not enough. So we have already been for years, we've been back and forth on this particular subject, that it becomes a chicken or the egg kind of thing, because they say, well, then it won't be protected if we then have to show it to somebody. Well, there has to be somebody to be able to corroborate that evidence code 1040 is being correctly applied. If we can't see the documents, then we don't know if it's being applied properly or not. So I have issues with some of the balancing tests around using evidence code 1040 as a blanket defense, and using 6255 also as a blanket defense, just to verbalize it. That's not enough. There has to be some substance to it. Now, with regards to the redactions of the metadata, only the information that is specific to identity is to be redacted. The headers that are auto-generated by whether it's Microsoft or Google or whatever other email server system creates that exists, which is based upon a reference code that is a standard internationally, so that everybody can receive email through their systems. It's a standard. Those headers are not protected because they exist everywhere and they are standard. It's like a page number is a standard. This page numbers are not to be redacted, are not protected information, so to speak. Okay, that so I want to make that clear, and I believe we have already taken a position on that. Okay. I'm not sure that the use of the pandemic is adequate or proper as a balancing test with regards to withholding records. I just don't find that how that is in the best interest of the public without explaining in great detail how it's in the best interest of the public that the records be withheld. Just saying pandemic is not enough. I think it's too short of an answer. So I'm ready to move on for this, but I wanted to at least address those issues for the record. And those are that way. The rest of the task force can also have know that there is some concerns about these defenses. Thank you.
Member Wong, anything to add on this?
Nothing that I can think of other than echoing what Member Wolf said specifically about the pandemic. I would imagine that the pandemic would actually help to serve like giving the public more records, just because we have less access during the pandemic. So just a thought as well.
Thank you. So, petitioner, would you feel comfortable having us close monitoring on this particular case based on what has happened so far and your understanding of how the department will respond to future requests?
I honestly would rather not come here again on this same complaint, just because I don't want to spend more time on this. I think Mr. Cote has stated on the record orally that if the IT people agree that that one field I want can be disclosed, they will disclose it unless they believe it's redactable under some other thing. My only concern is they may come back and tell me if you close it, well, it's those other three, right? It's not cybersecurity, but those other three. I don't know if they'll do it. I don't know what you want to do about it. So, but honestly, I'd rather be done with this as well. So.
Yes, Member Wilk, go ahead.
I would just say to that, look, this isn't a kind of a rolling machine where the reasons for withholding get to change at a whim. Okay, this is about information. This is about a request that was made at a particular period of time in the past. The reasons for withholding were given at that time. At the time of the complaint, those reasons were still the same. Okay, the reasons cannot then change moving forward unless it's for it absolute, like a new law got created for some reason. But these things live somewhat in celluloid because it's not about what's happening today. This is based upon an order of determination that was based upon information that of a complaint and a violation that was done in the past. So the reasons cannot continue to change. I just want that to be clear. I, as an individual member of this task force, will not stand for that.
May I then clarify my response to Chair LaHood based on what you just said?
Sure.
Okay. So the time, as of the time you issued the order of determination, the written justification provided by the Office of the City Attorney was Evidence Code 1040. And I'm just going to assume they mean 1040B2. I'm going to read it in the record, and if you don't agree with me that one field is subject to that one argument they made at the time of, at the time you had the hearing, it's your decision to make. And I'm just going to read what the justification. As used in this section, official information means information acquired in confidence by a public employee in the course of his or her duty and not open or officially disclosed to the public prior to the time the claim of privilege is made. A public entity has a privilege to refuse to disclose that official information and to prevent another from disclosing official information if the privilege is claimed by a person authorized by the public entity to do so, and either of the following apply. Disclosure is forbidden by an act of the Congress or of the United States or a statute of the state, or disclosure of the information is against the public interest because there is a necessity for preserving the confidentiality of the information that outweighs the necessity for disclosure in the interest of justice. That's very important. They don't say that. But no privilege may be claimed under this paragraph if any person authorized to do so has consented that the information be disclosed in the proceeding. In determining whether disclosure of the information is against the public interest, the interest of the public entity as a party in the outcome of the proceeding may not be considered. So here's what I'm saying to you. I don't believe the field that tells you whether or not the email was spoofed or not was, one, acquired in confidence by a public employee, and two, even if it was, it is not in the interest of justice to hide the information of whether an email was spoofed. I'll leave it at that and to whatever you want to do about that. Thank you very much.
So, Mr. Cote, I say that we appreciate the efforts to comply with the new metadata guidelines provided that are being provided by the IT department. Would you like to respond to this particular issue regarding 1040B2? Could we have some assurance that it won't just be applied in a blanket fashion going forward, but that it will only be applied when it is relevant? I'm not hearing a response. Was I not heard, or is
No, I can hear you. Fine.
Okay. Is Mr. Cote still there?
Sorry. I think I was on mute.
Oh, okay.
I'm
sure it was eloquent, but we didn't hear it.
Sorry, it's the classic pandemic moment. You're on mute. So a couple points I would just like to make quickly in response. First, to some comments from your fellow members of the committee about the issue of whether 6255 in the pandemic was whether we properly invoked 6255, and absolutely we did. So the point is, we were addressing this issue, and it was not being sorted out in a vacuum. It was in the midst of the pandemic, and our office was helping the city grapple with that unprecedented crisis. We were and we remain involved in nearly every aspect of pandemic response. So people were losing their lives, their homes, their livelihoods. City departments were struggling to provide essential services while keeping their workers safe. And our cybersecurity concerns were heightened because the city had just recently transitioned to remote work, making cyber attacks potentially more likely and more crippling. So that is why 6255 was absolutely appropriate. We're not trying to suggest that the pandemic is some kind of excuse. The attorneys and other staff in our office are working literally night and day, on weekends, around the clock, doing pandemic response. So that is exactly the kind of situation that 6255 was designed to be used for. Secondly, to your question, Chair LaHood, about evidence code 1040, our office uses it in an appropriate fashion. In this instance, we're only asserting official info privilege on things that the Department of Technology has already said are sensitive and are cybersecurity risks, and that Anonymous has agreed are sensitive and cybersecurity risks. So, we will continue that approach.
Okay. Well, Member Wolf, I see you're speaking, but I think you're on mute.
Yeah, I have nothing more to add. I suggest, in the interest of time, that we move to close this file and move on.
I think that makes sense. It sounds like even though we haven't gotten both parties to say the exact same words, it seems like they're on a similar path, and I would agree that we close this file, and if any issues come up in the future, we invite you to come back to us about this, but for the time being, I think we can close ongoing compliance monitoring. So do we have an official motion for this?
So I would move that that the committee cease monitoring on file number 19044.
Do we have a second on this motion?
I will second that motion.
Okay. Is there any public comment on this motion to cease compliance monitoring on this file?
Yes, there is. Can you hear me?
Yes. One moment, please. We're going to get ready with the timer. And Cheryl, whenever you're ready. Hang on. Cheryl, I think you're on mute.
Go ahead, Mr. Warfield.
This is Peter Warfield, Executive Director of Library Users Association. We are not associated with this complaint and haven't had any part in it. I did drop in to hear what's cooking, and there are some issues raised that I think are significant. I'm very troubled that time should potentially interfere with justice. And remember that all of these things set an example for the general public and are not just a matter between one person and one agency. This sets the tone, and this sets the expectations for other agencies and other members of the public in general. So I think you should take this as your own matter. In addition, I don't know why the complainant has to be present at future meetings. If you were to leave this open for further monitoring, I don't see why, and I don't know that the rules require the complainant to be present. It seems to me that if the agency provides the material, Mr. Anonymous could very well just simply agree, or you could make your own decision that your order of determination was complied with. I think it's very important, and that's a whole issue of enforcement and of follow-through and so on. Why do people repeat? Why is there such widespread flouting of the law? I think part of it is a lack of follow-up. So some particular things. There were tech problems earlier, and I had trouble in this case hearing. Just the volume and the quality of the sound was very poor for the complainant and the department. Number two, the last-minute provision of material, I think, is very, very peculiar and suspect. As I understand it, the law requires, after an order of determination, provision of material in 5 days, and I think that right away is a warning flag. With respect to providing keys and reasons and so on, how do we know? And I think the Chair Wolf made a good point, Chair in another part, with regard to how do we know. I have received redacted materials that gave partial information or that could be checked for reasonableness. So an email address that didn't even have enough room for the provider just seemed suspect. So I think there ought to be ways to partially redact so that it's clear that this is redactable. I don't think you should quit until this is really and truly done. And then in terms of balancing requirement, I thought the balancing requirement was a state law and not applicable in San Francisco specifically. But there may be other things here involved. So that's some observations. And I do think you should carry it out to the end yourselves and not burden the complainant with what's caused by delays from the respondent.
Thank you. Is there any additional public comment from members of the public who are not party to this case? Seeing none, let's please call roll.
Member Wolf?
Aye.
Member Wolf, aye. Member Wong?
Aye.
Member Wong, aye. Chair LaHood?
Aye.
Chair LaHood, aye. The motion to close the matter passes.
Thank you. Thank you, participants, for being here today. Cheryl, when you're ready, if you could please call the next item.
Item number 5, file number 19047, complaint filed by Anonymous against Mayor London Breed, Hank Heckel, and the Office of the Mayor for allegedly violating Administrative Code. Section 6721, 26, and 27, and Government Code California Public Records Act 6253.9, 6253, 6255, by failing to respond to a request for public records in a timely and/or complete manner.
Thank you. And just to answer a question that came up earlier, since this was the item on the agenda where I believe other information, hang on, I want to make sure, was, no, this one's correct. No, this one is not correct. Forgive me. The information in italics in parentheses should be from, this is.
It's just not correct.
It's just not correct. It should be for, it should reflect the respondents in the case. So this again is a matter of compliance and regarding metadata. Is the petitioner here, and is someone the respondent here?
Petitioner is present.
Yes, hello. This is Hank Heckel from the Office of the Mayor, responding for the respondent.
Okay, thank you both for being here today. To the petitioner, has the respondent complied with our order of determination?
Point of order, just a point
Yes.
of order, please, Madam Chair.
Yes.
The verbalization, kind of the announcement of this stated that it was alleged. This is not alleged. The task force has found violation.
That is correct.
So I just want to notate for the record that we are in a monitoring mode of a post order of determination. Thank you.
Thank you. I appreciate that clarification. For the petitioner, can you tell us, has the respondent complied with our order of determination?
First line is no, not at all, but there are happy things to say, so I'm going to tell you those. I wanted to read into the record what the correction to the agenda italics should be because it's important. I'm reading this from your order of determination. Quote, the SOTF found that Mayor London Breed, Hank Heckel, and the Office of the Mayor violated Administrative Code Sunshine Ordinance Section 6721, 6726, and 6727 by failing to provide records in a timely and or complete manner, keep withholdings to a minimum, and justify the withholding of records. So I'd appreciate all three respondents and all the violations correctly put on the agenda. So they have not actually produced any of the ICS calendar records in this complaint. However, any at all, they produced one ICS calendar record after the deadline of some other records, some other requests I made to prove that they have the capacity to do this, and then entered into they have agreed with me to use the new DT system, if they so choose, to provide rolling response across the next 60 days of the ICS calendar records of both the mayor's Prop G and non-Prop G calendars, and that also was an issue in this OD, and to do so within the next 60 days, and to provide a key by footnote or reference for every justification, specifically the ones that aren't using information security risk. And so what I believe is we're jointly requesting you, and I assume he's going to ask you to do the same thing, is that you continue this matter 2 months later. So the March compliance amendments hearing, and they should have produced all of the records by then, and we can judge whether they, justified it, minimally withheld, etc. At that time, that would be my request to you. And I'm not going to just go through all the legal arguments because just for time. Thank you very much.
Thank you. Member Wolf, I see that you have a question. No, that was just a continued hand raise. Mr. Heckel, could you tell us, is what the petitioner said, does that reflect your understanding of how you're working together to produce the documents?
Yeah. Thank you, Chair LaHood, members of the committee. I agree with some of that, maybe not all of that, but I think the takeaway is that, yes, we have agreed to provide the requested metadata in the calendar ICS files in issue. In this case, we provided Anonymous with an example of an ICS file redacted consistent with the advice we received from the Department of Technology and using the sort of pilot redaction protocols that they've provided. And so, we basically gave that to say this is, what the production will look like, and we'll produce the rest of all of the calendar entries at issue. There were quite a few more an issue, maybe 30 to 40 individual records or so that have to be provided to DT for them to sort of run this redaction program. So that's why we said we would do it over the next Anonymous proposed 60 days, and we're fine with that. We, my understanding was we basically reached agreement with Anonymous on all of the matters in dispute, and that we'll provide that information over the next 60 days per his terms. And then, if there's anything left to discuss, we can do that at the March hearing if we can get that on the agenda. But we've consulted extensively with the Department of Technology over the period that this has been an issue. Everyone on the committee is aware of the complexity and sort of novelty of this issue, and we had to rely on our IT professionals, and we worked with the city attorney to make sure we were we were doing the right thing in terms of the cybersecurity exemptions that could be applicable. And Anonymous has conceded, of course, that some of the information is withholdable, at least under 6254.19 in the PRA for cybersecurity reasons. And so we will defer to the Department of Technology, at least for these files, to tell us, what is on the black list versus the green list in terms of metadata, and then provide that. They can run the records through this pilot redaction tool that they've developed that they at least can use themselves. And we did provide that record. The day they made that tool available, we were able to use that to provide this metadata information to Anonymous, and we'll continue to do so, and we believe that we will have complied then and can close this out.
Okay, thank you. We appreciate those comments. Members of the committee, do you have any additional questions, or how do you feel about continuing this and checking in on compliance again in 2 months? I am seeing nodding and thumbs up from the members of the committee. Would someone like to make a motion to this effect?
I'll make a motion to continue this matter, file number 19047, to the March Compliance and Amendments meeting.
Second. And it's specifically for monitoring.
Yes. So does the member Wong does your motion is specifically for monitoring this?
Yes.
Okay. So we have a motion, we have a second. Do any members of the public wish to make comment on this motion? We're asking for comment from anyone who is not a party to this matter.
Yes, please.
One moment. Cheryl, are you ready with the timer?
Yes, I'm ready. Go ahead, Mr. Warfield.
Yes, this is Peter Warfield, Executive Director of Library Users Association. And we can be reached at libraryusers2004@yahoo.com. We're not a party to this, and in fact are not familiar with it. I wouldn't say that I'm opposed or that we would oppose this with some provisos. First of all, I think that the task force should be satisfied that this is a reasonable solution. We don't want to have people, for whatever reason, denied what they're entitled to, including with respect to timing, just because they perhaps made a mistake or were pressured into some kind of an agreement that goes beyond the bounds of what the law requires. If the law requires 5 days and folks say 60 days, certainly I think that the task force should consider whether that's reasonable or whether something more stringent ought to apply. With respect to the erroneous agenda item, I certainly hope that this will be noted in the minutes and perhaps in a future agenda. I think it's important for people to understand what the issues are. I mean, that's why we have agenda requirements under Sunshine, so that people can understand what the situation is, who's involved, and what the issues are, and so on and so forth. So I hope that you'll make definite efforts to make it visible that this agenda item was not correct and give how it should have been. I did want to mention something in general and on the previous item from Mr. Cote. COVID-19 undoubtedly has caused a whole lot of...
I'm only taking public comment on this item, not on previous items.
All right. All of the concerns that exist currently for whatever reason, including temporary, we hope, conditions, need also to be evaluated, and the public is certainly working under difficult conditions and may be under extremely difficult conditions as well in trying to make our democracy and our laws work.
30 seconds, sir.
Thank you. Done. Thank you.
Thank you. Is there any additional public comment on this item from members of the public who are not party to this case? Seeing none, please call roll.
Member Wong?
Aye.
Member Wong, aye. Member Wolf?
Aye.
Member Wolf, aye. Chair LaHood?
Aye.
Chair LaHood, aye. The motion to continue this matter to the March Compliance and Amendments Committee meeting passes.
Thank you.
Thank you, everyone, for appearing for this matter. Cheryl, whenever you're ready, let's call the next item.
Can we take like a 5-minute break before we do that?
Yes. In fact, let's take, we'll take a 10-minute break. We'll come back. Right now it's 6:17. We'll resume at 6:27.
Lila, can you hear me?
Yes,
Hello.
I am back.
Thank you so much. I had to get a blanket and a space heater. My dining room is freezing.
It is freezing here too.
I just pray to God nobody
It's really good.
knocks on the door and says they have to get in from the rain.
Hello, hello.
Yes, we'll get started in just 1 minute. I think we're waiting for Member Wolf to return.
I'm back.
Great. Cheryl, if you're ready, I think we are all here.
Okay. We have returned to the Compliance and Amendments Committee meeting. It is now 6:29. Item number 6, file number 19145, complaint filed by Chris Kors against the Police Commission for allegedly violating Administrative Code Section 67.5, 6721 by failing to respond to a public records request in a timely and/or complete manner.
Okay, thank you. Do we have is the respondent here? Or, excuse me, is the petitioner here? I'm sorry.
Yes.
And is the respondent or a representative here?
Yes.
Okay. Just to do a quick summary of what we have here, this was taken to the full task force, but we don't have an order of determination. It was sent back to us to gather some more information and seek legal guidance. Should I give a summary, or should we hear from the members? Should I give a quick summary, or should we hear from the petitioner and the respondent first? I'm going to give, I'll give a brief summary. This is regarding a recording of deliberations in closed session, whether they were recorded. I believe at this point, and I'd like confirmation from the respondent that they were recorded, whether that is a public record and whether some withholding is allowed on that. So I guess first I would like to ask the petitioner, have you received the recording that you've requested?
No.
Okay. And to the respondent, does this recording exist?
Yeah.
Okay. So we know the recording exists, and respondent, if you could reiterate why this has not been provided to the petitioner.
It has not been provided to him because it is a closed session item. We actually placed it on the Police Commission agenda at the last meeting or meeting before. The commissioners voted unanimously not to disclose nor to waive their attorney-client privilege.
Okay, so we know that the recording exists. The Police Commission asserts, it sounds like they assert that there's attorney-client privilege on this. I think based on I'm seeing Member Wolf. Member Wolf, would you like to say something in response to this? Because I think that is not in alignment with what our understanding.
Yeah, I'm not clear that the assertion of attorney-client privilege was made at the time of the hearing. It was the prerogative. What was missing was the deliberation portions of the closed session. The rest, from what I understand, I think I left that meeting, was that Mr. Kors had received the other portions of that meeting, but that the police commission had decided not to release the deliberation portions, but that Sergeant Youngblood had confirmed that they did in fact exist. Further, that yeah, I'll just stop there.
Okay, and just to clarify, I believe that based on our research and guidance, that we believe that this is a public record, although we understand that there may be some withholding allowed. And the question is whether that's indefinitely, whether it's for a certain period of time, and whether we currently still fall within that period of time based on certain requirements. Please go ahead.
Yeah, just one additional point that I wanted to make was that Sergeant Youngblood had also testified that that it was at the that in previous. This is not. There's not like a set standard that the commission takes prerogative over whether they actually do record deliberations or not record deliberations, and what have you. So there's no real consistency with regards to that. I think some of the comments that the task force brought forward was that if you're going to have if you're going to record your closed sessions, there are provisions that are there are guidelines with regards to that. And I think that's kind of where we're at this point. I thought that we had gotten, we'll hear from we can hear from the parties, but I thought that the deliberations were going to be made available to Mr. Kors, but I could be wrong. We'll listen to the parties on those parts. I don't want to guess.
Well, then, are we asking then? It sounds like, based on what the respondent said, that the commission voted not to release this. Is that correct?
Well, but he just said that it was based upon attorney-client privilege.
Right.
I'm not following that, because that wasn't the reason that was given at our hearing. So,
can I clarify?
One moment, sure, but I'm just a little concerned about moving targets here at this point. So I'll stop there and I'll listen. Thank you.
Yes, please, if you would clarify.
So the police commission put it on the agenda of whether they were going to release the deliberations, which are not public documents. They voted unanimously not to disclose. And during deliberations, they confer with their attorney. So there is a client privilege in deliberations. However, they voted unanimously just not to disclose. It wasn't due to attorney-client privilege. They just voted not to disclose because it was not a public document.
So, Sergeant, if I can just follow up real quick, Sergeant Youngblood, are you saying that the commission itself has determined that these are not public documents? They're not publicly disclosable?
They are not publicly disclosable, no.
And why? Under what citation or what reason are they stating that?
They're not disclosable because they are part of a personnel information. Christopher Kors public personnel information, so they are not releasable.
That's how he got the other recordings, is because he was a former police officer asking for his personnel records. The deliberations that he received was voted by the commission in their meeting during closed session not to disclose. Therefore, they were not disclosed.
I guess what I'm asking is under what specific authority can they do that? There has to be some law that allows them to withhold records.
It's under 832.7 that they're withholding documents that are personnel information or personnel records for an officer.
Excuse me, sir, was that 832.7?
Yes.
Yes, and is that government code?
That is the government code, correct.
Okay.
So just to, so with 832.7, I know there are exceptions under certain circumstances, use of force, sustained finding of sexual assault, or sustained finding of dishonesty. So are we assured then that this has nothing to do with any of those cases which would make them disclosable?
These are not Senate Bill 1421 documents, no.
So members, seeing as they are not disclosable under these exceptions, then it would seem that this recording would not be a public record unless you have a different understanding. Or would you concur with that interpretation?
As far as I know, that seems correct to me.
I need to review that list for a moment.
Okay. Members of the public and petitioner and respondent, if you could just give us a moment. We are still here, but we are just reviewing the information in front of us.
And sorry, just for the record, 832.7 is a penal code. Apologies for that.
Thank you for the clarification.
Is it penal code? Okay.
Members, one thing that I'd like to note and request your feedback on, it seems that the confidentiality of closed sessions does expire at a certain point, and that even though records are not public records now, they could become public records in the future. Is that your understanding as well? And it looks like
Yes.
in 2 years, so 2 years after the recording is made, even though it's not currently considered a public record, 2 years from the date of the event, it would become a public record. Is that correct?
Yes. As long as that file has been closed.
So as long as there's not any ongoing litigation related to that file.
Right.
And would that
if the investigation or the issue is applicable under law for it not being disclosed.
Right.
Okay. I mean that's part of what we're here to also determine as to whether it's disclosable or not. In that kind of way. Now, that doesn't mean there are. I will say this: whatever the task force decides in favor or not, in favor for one party or the other, there are probably other venues that this case can be brought to. The fact that this is happening in a open and public meeting, in a closed session, which is governed by state law and local law, is why it's before us. So, but there may be other venues where this can be dealt with regards to civil service, labor arbitration or labor laws and things like that. There's plenty of I think there are other venues too. I just want to ask Sergeant Youngblood, for you cited 832.7. That's a fairly lengthy, hefty bit of code. Do you have anything like a specific paragraph in there that applies? Because some of it doesn't really apply to this particular issue.
I do not have the code in front of me. I believe it's A, but I am not 100%.
Okay. I just want to check if I missed it during the previous meeting's testimony, if it was in there. Okay. Go ahead, Madam Chair. I'll read this through. If there's any other questions you want to ask of any of the parties, or
actually to the members, just to verify, even though such a recording might not be a public record now, but would be a public record in the future, we are responding to the request at this moment. And if it were to become a public record in the future, as you say, it would be the petitioner's responsibility either to request it again or to use a different venue to request that document. Is that correct? It's not our responsibility to respond to what would happen to this document in the future. Is that correct?
That's absolutely correct. Because the law applies and they would just have to wait it out until that period of time. But we're not actually, we're adjudicating this in real time, but this is based upon incidents that happened at a previous date.
Right.
Okay, so that's another situation. I know that there is state law relating to some of this matter that has yet been heard by the. It's just been introduced, but it's not. I don't think it's yet been heard by the legislature yet. That is further expanding on the disclosure of records with regards to police conduct.
Right. At this time, and I guess I would ask the petitioner, So it seems that based on our understanding of 832.7, because the hearing did not pertain to the areas of exemption that would make this recording a public record, does that align with your understanding of what would have been contained in the recording of this hearing?
Well, so what you're saying is, did this thing have to do with sexual assault or something like that? Is that what you're asking?
Yeah, I guess, I mean, the exemptions are use of force, sexual assault, or sustained pattern of dishonesty. If do you think that any of those exemptions would apply?
Not in this case, but I do think 67.8-1 of the ordinance states all closed sessions of any policy body covered by this ordinance shall be either audio recorded or audio and video recorded in their entirety, and all such recordings shall be retained for at least 10 years or permanently where technologically and economically feasible. Closed session recordings shall be made available whenever all rationales for closing the session are no longer applicable. And I don't see any reasons why anything would be applicable. All rationales for closing the session are no longer applicable.
Was that Mr. Kors who was speaking?
Yes, that is.
Yes. Can you give me that citation again? 67.
67.8-1 of the ordinance.
Thank you, sir.
Yep.
Madam Chair.
Yes, please.
So, that I kind of contend to the same issue. The question is if the respondent is claiming a citation that allows withholding, that could be valid. The question becomes whether, based upon 67.8-1, whether that survives, whether that withholding, that citation for withholding survives the provisions of the ordinance. Like if it's in a sealed file or something like that. Sealed files may not be, while they could comply with 67.8.1, there is now a caveat because it's a sealed file and is protected under court order or something like that. There are those kinds of situations. I think the question we have now is, and I think we heard testimony on this, is whether the case against Mr. Kors is now closed with regards to the police commission. They made a final decision. Is the case now, and at that time there was no litigation. There was no anticipated litigation. Mr. Kors at our hearing I believe he testified that he was not planning any litigation, and at this point the matter seems to have been concluded. So as I mentioned in my testimony at the task force hearing, I pretty much still stand with 67.8.1 that all parts of that closed session, I'm not convinced by 837. What is it?
832.7.
832.7. I'm not so convinced that now is active anymore, because if the case is closed and concluded, that now 67.8.1's provisions now apply in full. I don't believe that it can be arbitrary. You know, whether the policy body can make it arbitrary or not, unless they have explicit authority to be able to prevent something from being withheld, which we not necessarily have heard. You know, that is that's what I'm going with. I'm just wondering, was 832.7 cited in the at the initial hearing?
I'm almost certain that it was, because this number is very familiar to me. I think we've been hearing about it all along.
Okay, I just don't see it in my notes. But okay, I haven't rifled through the pamphlet, but I'm just looking at the response, the respondent's response to the complaint. I don't see those numbers in it per se. So if it was mentioned in testimony, I just didn't have that recollection. Okay, thank you. So I guess, well, maybe, I guess the question then for Sergeant Youngblood is, has this case been finally concluded and the file closed by the commission, police commission?
Well, Mr. Kors was terminated and lost his appeal, so I guess, yes, you could say it is closed with the commission. But it's still a personnel record, so it still wouldn't be able to be released.
Okay. Thank you.
Members of the task force, is your understanding that after the expiration of, if it's no longer an open case and after 2 years, that it would become publicly available? Does that also apply to personnel records, or does that not apply to personnel records?
Well, if I would say that if the laws or the codes allow for those records to remain withheld, beyond a certain period of time, that probably would be a valid reason for them to remain withheld. The question becomes is what, even if the closed session under 67.8-1 was applicable, the question is whether the records, if they are ready, if now after 2 years they're ready to be disclosed, if they are still restricted from being disclosed based upon other existing law, then that has to be considered. I'm not saying considered in the positive or negative, but it just has to be considered with regards to whether it's still applicable or not. That law is still applicable for those records or not. Did I articulate that okay?
Yes, but I'm still trying to figure out whether that applies in this situation.
Well, the question for me then is whether 832.7 is still applicable to these records if the case has already been concluded. If the case has been concluded, are then these records releasable? Once it's just like an investigation. Once an investigation is over, and the file is closed, the record then becomes somewhat disclosable at that point. There may be some cooling off period or a period of time, but at some point in the future, it does become disclosable. So that's really my question here. If the question with regards to personnel records is, are all personnel records always not disclosable? and what are the conditions around that? And that's really the burden of the respondent to produce. And that's why I was asking for the specific paragraph in 832.7. I'm just going to review the minutes because if it's already been testified, I don't want to rack Sergeant Youngblood's brain because he's probably got a million other things on his mind too.
So I guess my understanding was that 832.7 is the justification for the closed session. And if that's the case, the record will always be a personnel record and therefore always remain closed and non-disclosable.
Unless it meets one of the three exceptions.
Correct.
And then even for those exceptions, there are counter exceptions which expire after the case is closed or after 2 years. Is that your understanding?
I don't think that third point was part of the understanding because 832.7 is that justification for the closed session.
Yeah, but we're not concerned about the justification of the closed session. We're concerned about whether we already know that the closed session happened. The original discussion around this was that there was like a beginning and an end of the closed session, but there was this missing part around the deliberations, and there was what was brought forward in testimony was that by the respondent was that sometimes they record deliberations and sometimes they don't record deliberations, and that is really at the prerogative of the committee. The contention of the task force at that time, and they may still hold that contention, is that if you're in closed session, the requirements under 67.8-1 in general for policy bodies is that anytime you go into closed session, the whole thing must be recorded. You cannot abridge it, and you cannot redact it. That the whole thing must be done. And we went through this discussion about how the mechanics of how they go about doing their recordings. There were multiple tracks, and so there was this there's a track for this part of the conversation, another track for another part of the conversation, and then another track for another part of the conversation. The deliberations were in a separate track, and at the time that we were told that the track didn't exist. And also recall Sergeant Youngblood wasn't at this meeting. This was being operated and managed by other people at the time. So I think I got all that correct. Sergeant Youngblood, am I explaining this more or less correctly?
Except for the fact that we always record everything in closed session.
Okay, thank you. So then, the question then becomes whether this is, I think the point is that if they followed 867.8-1, then everything applies in 67.8-1, except if there is some other citation of law that authorizes them to withhold the record. Okay, and so even though it may be a public record, it still may not be disclosable, even though the record exists. So the first question is, did they follow the rules for closed session? I think we're at this point where they have. They recorded the entire thing. Okay, if it was disclosable, could they provide it? I think the answer is yes. The next question is they're citing a provision that protects it from being disclosed. So like any other public record, I think that's where we're at right now, is whether their citation of 832.7 of the Penal Code applies. And I think that's kind of where we're at this point. And let me ask, Mr. Kors, did you receive any part of that closed session? Just remind us.
Yes, I did. And please don't forget, one of the parts that's really concerning is Ashley Worsham's statements that are missing at this sound bit. I mean, here's the playback.
What you saw on a page status is
So we're not just talking about the deliberations missing here. I mean, we're talking about her statements missing from the audio recording and transcript. And we haven't gotten any, they're not providing us anything, any evidence to prove or disprove their claim. And if they really want to bring transparency to this, give us the tapes and let us analyze it to prove that you're right. But they're not. It's more than just the deliberation. Just please remember that. And also, it was a public records request. It's documented multiple times. It was a public records request. In fact, if you go on right now to the online public records request portal, you can pull it up and listen to it yourself. I mean, I can give you the page numbers in the evidence packet where it clearly shows it was a public records request.
I don't think, Mr. Kors, I don't think we're disputing that part unless you think we're missing something with regards to that. I think we are in agreement that whatever happened during that meeting, during that closed session, that the record is public. The question that the respondent is bringing up is, or their reason for withholding it is based upon certain law that they say allows them to withhold it. Okay, so I don't think we're disputing that it's not a public record. Are you thinking that we think something differently?
Well, if it's a public record, then why can't it be made available to the public to examine and listen to? Well, then they're not providing that.
Well, but you see, that's the point of trying to make. I gave the example of, let's say, a law enforcement investigation. The record, the file itself is public until it's deemed to be. Even though it's public, it's not disclosable until it's deemed disclosable. So it can't be disclosed. And if for some reason that file remains open, or if the court seals that file, then it'll never be disclosable, even though it's still a public record. So that's kind of where we're at this point, is whether the reasons that the respondent is bringing forward for withholding, they're stating that under the authority of the Penal Code of 832.7, that these records are to remain not disclosable, whether or not. Go ahead.
I'm not sure that unless, I think based on my reading, and please correct me if I'm wrong, but under 832.7, unless the records fall under one of the three exceptions, I don't think they're public records. Or are you saying they are? Jen, are you saying they are not public records unless they fall under one of the three exceptions?
That is my understanding.
Okay, in which case, if these records, if one of the three exceptions, which it seems that both parties agree do not apply in this case, then the recording of this meeting is not a public record.
So let me just ask it. Where can you point to me what the three exceptions are?
So the three exceptions are.
Is it B1B?
B1 A, B1 capital A 1 and 2, and capital B all of. Excuse me. B1 A, B, and C, and all of the subheadings under those.
Lila, B1A, what exactly is that?
Okay, so 832.7, B1A, B1B, and B1C.
Okay, so Madam Chair, reading the preamble for 832.7, it says, except as provided in subdivision B, which we are in. Okay, so except as provided in subdivision B.
So except the ones that I mentioned. Yes.
Right. Okay. Okay, so if we go to the preamble of B, okay,
yes.
Notwithstanding subdivision A or subdivision F of section 6254 of the government code, which is the CPRA, or any other law, the following peace officer or custodial officer personnel records and records maintained by any state or local agency shall not be confidential and shall be made available for public inspection pursuant to the CPRA.
So that's only everything that follows. You have to go back up to what you called the preamble and read the preamble part, which says, except everything in B, the personnel records of peace officers and custodial officers and records maintained by any state or local agency pursuant to section 832.5 or information obtained from these records are confidential and shall not be disclosed in any criminal or civil proceeding except by discovery pursuant to blah, blah, blah. The section shall not apply to investigations or proceedings concerning the conduct of peace officers or custodial officers or any agency or department that employs those officers conducted by a grand jury, a district attorney's office, or an attorney general's office. So the exceptions don't apply in this situation.
Okay. Okay, so I guess, Mr. Kors, based upon that fact, whether the question for me then is do you still think that the well, maybe I shouldn't be asking you. The burden is really not on you; it's on us. I guess the member. Let me ask members. I guess for the sake of trying to bring a recommendation back to the task force, despite that the record exists in the medium of a closed session of a public meeting, shall that record be considered public under the CPRA and the ordinance, but not disclosable? Hold on.
Well, that's an interesting question because I suppose.
Oh, I see. You're saying that it's not even part of the public record.
No, it's not part of the public record because the content does not fall into one of the three exception categories.
I get that. So here's the rub.
Yeah.
This proceeding happened not in in an administrative office. This proceeding happened in a public meeting that is governed by a very specific public hearing, open meeting laws. okay, that are not just local, it's state law too.
Right.
So the complainant is contending that despite 832.7a, where the content of the information is not, he may not be saying this. The respondent is saying that the content of the information is not, shall not be disclosed in any criminal or civil proceeding. It's not that it's not a public record. It's not disclosable. It says that any information from these records are confidential and shall not be disclosed. It doesn't say that they are not public records.
I see what you're saying, because you're saying the container of the meeting, because of the Brown Act, makes it a public record, and it's only these exemptions because of this code that make it not disclosable.
Right. I mean, all records created by public agencies are public records. Okay. If you take a Post-it note and you write a note to yourself, that's not a public record. Okay. But the fact that this information, the personnel records of peace officers and custodial officers, are public records. They're maintained by a state or local agency. Okay. So they are in fact a public record. They have to be a public record. Okay. They cannot be deemed as not a public record. What the authority to withhold them based upon 832.7 is that the information, the actual records that are maintained, or the information in the records or obtained in the records, those records are confidential and shall not be disclosed in a criminal or civil proceeding. Okay, and there's an exception to that with regards to discovery pursuant to sections 1043 and 1046 of the evidence code. Okay, we have not gone down that road on those points, because we have to, that I don't know what that may be something that we need to do, and I don't recall that legal counsel had done an analysis of 1043 or 1046 for us.
I don't think for that.
Right. So, and in the following section, the following sentence of at the end of A only applies. It would not. It would basically not apply to investigations that are in front of a grand jury, a district attorney, or attorney general's office. Then it would be disclosable at that point. So the rub here is you're right, the container of what the information is contained in. First of all, it's in somebody's physical file, right? Their personnel file, and then the dispensation or the dispensing of the issue is being done in a different container, but still part of the same overall large, main container. The smaller container being the hearing. So the only thing that's left kind of dangling for me is sections 1043 and 46 of the evidence code, or whether that applies or not, because that's the only caveat for us to determine whether the records are still public or not. And I would say absolutely we now that the door has been open under as the presentation of 832.7 as the reason or the justification for withholding, 1043 and 1046 absolutely applies for us to review.
Are you saying that the Sunshine Ordinance may be able to, that we through the Sunshine administration of the Sunshine Ordinance may be able to request this because through 1043 and 1046, and we don't know it?
Well, the question is the respondent is claiming that 832.7 is their justification for withholding.
Right.
832.7 has a caveat. The caveat says, except by discovery pursuant to sections 1043 and 1046 of the Evidence Code. So if 1043 and 1046 apply to this particular situation, then the records cannot be confidential and must be disclosed.
Is DCA Price Wolf on this call?
I don't think so.
Cheryl, do you?
He was invited. He was invited.
Okay. Oh, he does? Okay. All right. Well, that to me is kind of where we're at. That's the best for me. That's where I can distill this down to. That yes, I think the petitioner is correct that the under all intents and purposes for 67.8-1, whatever the subject matter is, the question is did the police commission follow the rules under 67.8-1? That's the first question, and we dealt with a lot of that at the hearing. The next question is whether under 67.8-1 are there any reasons for the records to be disclosed? Okay, the provision is that when closed session recordings shall be made available whenever all rationales for closing the session are no longer applicable. The petitioner is stating that there is no rationale and for that there is no additional rationales for withholding. The respondent is claiming that under 832.7 that the information is they're authorized under that section to continue to withhold the information that is part of that closed session, the records that are in it. And we're not talking about redactions here. We're talking about actual withholding. Now, some of the information has already been provided to the petitioner. He has it. It's actually part of the public record because it's in now the request, the actual request. But the other part of this, and I don't want to forget that he brought it up, was that part of that recording is missing. And he's interested in getting the rest of that recording, and now that's public. The question now, then I'll pose the question to Dr. Sergeant Youngblood is, can you make that section that has been that is missing available to Mr. Kors?
Mr. Kors has made an accusation that there are pieces of the audio recording missing, and we continue to claim that there is nothing missing from the audio recording.
Can you explain why the recording sounded like there was?
I don't know why it sounded like it was. I can give you a whole bunch of reasons why it might sound like that, but again, it would just be guessing since I wasn't there that night. But it's not. We did not alter it. There's nothing missing.
Okay. Thank you. That's all I got. for now.
Can I make a statement? This is the petitioner.
Sure, if you can keep it brief.
Since Sergeant Youngblood wasn't even there, why are we talking to him? I mean, why can't we get Ashley Worsham? I mean, she's the one that made the comments that are not even in the in the recording.
You know what? I'm gonna stop you there. The agency is allowed to send a representative of their choosing, and we're not in a position, as long as we feel as though the representative is able to adequately answer our questions. They have fulfilled their duty.
Okay, Stacy Youngblood has changed his story multiple times. Do you feel like he's adequate to answer your questions?
That's a, you know what? I'm not going to get into a back and forth on this. So to the members of the committee. What do you propose that we do at this time? It was our mandate to gather more information, to be able to make some sort of proposal back to the full task force. I'm looking up evidence code 1043 and 1046. I'm not sure. Would you like me to read this to you, or is that?
I have them pulled up over here as well.
Okay. Do you have any? Please go ahead.
I was also just going to say that I assume that if they had applied, or if there was applicable pieces of it, it's something that DCA Price Wolf would have informed us of in the email that he had sent us. Hey, Cheryl, can you mute again, please? Thanks.
Yeah, I'm looking at this, and I agree. I'm not seeing anything that I think would either support or refute anything in this particular, and anything that we're considering at the moment.
Yeah, 1043 is actually an instruction for the person seeking the records on how to obtain those records, but it's not it's I don't believe it's not applicable to us.
Right.
Yeah, I'm kind of I'm sorry, I'm kind of at a point where, let's see, I don't want to speak too soon, because this is going to go back to the task force, and I might have a different notion. So I don't want to think out loud too much right now. I would say that what we could bring forward to the task force as a recommendation is that the record in its entirety, however parts of it have been made public or not, just on the face of it, separating the content of the what was being said, just the operation of the closed session seems to have been correct. That would be the first point.
Mm-hmm.
There was a record. It was recorded in full. We heard it the first time that maybe that the deliberations weren't there. Then we heard that the deliberations are there. So we know that the record exists in full, which the petitioner only has part of it. The question then becomes, can the rest of it be disclosed? And that is what's being withheld from the petitioner based upon this 832.7 of the Penal Code.
And based on our reading of it, it appears that they are confidential and could only be disclosed through criminal or civil proceedings through the discovery process, which is not our process.
It would be well, that's one way. The other way is if in the proceedings there were investigations or proceedings that were conducted by a grand jury, a district attorney's office, mm-hmm. or the attorney general's office. Okay,
right.
In kind of a more an internal investigation type of way.
So that there are other ways for it to be disclosed, but not through the Sunshine Ordinance.
Right. And by the same token, sections 1043 and 1046 of the Evidence Code is open. The way I'm reading it, that procedure is open to the requester to be able to get access to the information.
Right, but not through the Sunshine Ordinance. Or
not
by
our
bringing
it's not our jurisdiction. Yeah, it's not our jurisdiction. This is way out of our jurisdiction to be party to that. That's kind of where I think that's kind of where we're at this point.
Okay, so then are we making a motion on our recommendation to send it back to the task force? Because this does need to go back to the task force.
Right. So I think our recommendation should be more like our findings. Okay. Because our findings could be challenged. But I think based upon what we've heard here today and what we've discussed, and I do think we should give a little time for rebuttals to each of the parties before we actually make a motion. But the operation for us right now is to make a recommendation providing findings, additional findings, and conclusions that we may have come to, and in the citations that are provided and what we've been talking about. And then let the task force have that additional information, and we'll see if they can make a decision or not.
Okay, so in the rebuttal, I should let the respondent
go first.
So, Sergeant Youngblood, based on our discussion today, is there anything that you would like to add or that we should consider in making our recommendation to the task force?
I can't think of anything now.
Okay. Mr. Coors, is there anything else that you would like to add or you would like us to consider in making our recommendation to the task force?
Yeah. How is someone supposed to, I guess, fight this or get an unaltered transcript and recording of their hearing without getting deeply involved with all sorts of lawyers and ridiculousness like that? I was kind of hoping that this would be a place where transparency would be brought out, and that we could actually find truth and transparency, and that's all that I'm requesting. I wasn't trying to go through any other means to do this. I thought that's what the Sunshine Ordinance Task Force was here to do. I guess there is one other avenue. You did say if the district attorney gets involved, that could be that is an avenue. DCA Price Wolf, what's his stance on this? What is has there been an analysis on these issues? It's a question that I just want an answer to, if possible.
So DCA Price Wolf is available to the task force to advise us on our legal questions. His role is not to provide advice to specific petitioners. I'm trying to think if there's anything else to add in that matter. You're right. We are here to hear complaints and requests from petitioners to try to help them use the Sunshine Ordinance to the full extent that it is available. It does have its limits. There are other ways and other avenues and other venues that members of the public may use to seek access to information that might not be able to be made, that they might not be able to access purely through the Sunshine Ordinance or the California Public Records Act. Members, is there anything else that you'd like to add to that?
Yeah, I would just say I understand, Mr. Kors, your point. The problem is it's not so much that whether the process. The first and key point is whether the process was complied with. That is definitely within our jurisdiction. But there are certain records that we don't necessarily have control of the records. All we can do is determine if they are public or not. And at that point, the respondent has the opportunity to provide some justification for them to be withheld. And our due diligence is to assure that reason, that justification is ironclad. That's our job with regards to what's in the best interest of the public. So that's kind of where our impasse is at this point. I don't think that there's any dispute that the closed session did happen. That is a fact, and that the closed session was recorded. That is a fact, and that it still exists, and that is a fact. Now, as far as the fragmentation of any part of it that you've received thus far, the question is whether if it is public, I don't know how much more we can try to compel the police commission to try and provide any missing parts that have already been made public. But for the area, the section that they're calling deliberations, they're claiming continued justification based upon the penal code. We cannot refute that. That would have to be overruled by a court. We are not a court. We don't have that enforcement authority. We can't even put people under oath. The voters didn't provide us with that privilege. So our abilities to fully adjudicate this are limited. In fact, if we find we make referrals all the time to many different kinds of departments. It's up to them whether they want to carry out enforcement or not. All we can do is determine whether the records are public and disclosable. And that is kind of where we're at right now. We find the records are public. We find that, that they were, at least the findings are that they, so far, they've complied with 67.8-1. Question is are any of the provisions now applicable? If they are applicable, as you're stating, around the rationale for for keeping it closed, keeping it closed are no longer applicable, and they should be released. That may and well be correct. But now, if that's the case, and now they're ready to release them, they're saying, well, wait a minute, we don't have to release them because they're personnel records that are protected under 832.7. 832.7 is not within our jurisdiction, except if the kind of the test as to whether this information, these records, are not applicable under 832.7. And I think there is somewhat consensus here that these records are, that 832.7 is applicable to these records, even if they were releasable under the Sunshine Ordinance, under 67.8-1. I think we're beyond the 67.8-1 based upon your reading that, the closed session, there's no rationale for keeping it anymore because the case is over, what's been done is done, and the file has been closed. They're saying that the personnel record is still not disclosable because of 832.7. That's a different issue, pretty much for a different venue, I'm afraid.
So, one quick comment. You said that they've complied with everything and that they have provided you all the recordings. Have you actually heard the deliberations? Because Stacey Youngblood stated quite clearly that they didn't exist. And I could here. Please just take a quick minute and listen to this.
So let me ask again, Sergeant Youngblood, is that part of the meeting where the deliberations happened, was that retained in a recording?
I don't think we need to listen to this because there were subsequent meetings when we, it might have been over email. It was determined that the recording for that portion does exist. You don't have it, we don't have it, but we've been told that that does exist, but that they are not providing it.
And we are going to go off their word, I guess, is what you're saying?
That it does exist?
Yes.
I can't imagine why they would say that it exists if it doesn't exist.
I guess I hear what you're saying, Mr. Kors, and I think because of these hearings that something did happen, and that by the recording that I think the recording that you just played, which was me speaking, and that was from the very beginning when the case first started. And I think subsequent to that, things began to materialize. Okay, that is somewhat the purpose of the task force, is to compel the production of records. But where records are being withheld by other areas of law that we don't have jurisdiction, we can't overrule those records unless their citation is absolutely incorrect. And some of that, is part of the theme of some of the cases that we've been hearing tonight, is whether those records are disclosable or not. and for what reason. This is somewhat, when it comes to personnel records, it's pretty much cut and dry. Other types of records, not so much cut and dry, as we've heard in earlier tonight. But I'm a little hesitant to try to find a way. I can't, based upon the evidence that's in front of us, I don't see a way that these particular records are available for us to be able to compel their production. I'm not saying that it couldn't be done in some other venue, but the Sunshine Task Force is limited, and it's not meant to be the kind of the end of the road. It's actually the beginning of the road. If you go to court and you are claiming a public records a compliance issue under the Public Records Act or the Sunshine Ordinance, the court is going to ask you, did you exhaust the local administrative process? And you can confidently say, yes, I have, because that's why we're here. But it's a court that will be the one to compel the police commission to produce the records. It's not, I mean, it's only by our ability to refer it somewhere else to do that, but we have to have justification to be able to do that. Otherwise, it's kind of like they'll laugh us out of court. So I agree with you just on the face of it, that yes, that's what we're here to do, is our job is to try to bring as much transparency as possible. But where the records are not disclosable and they can be withheld, we have, unless there is some other piece of evidence that can show us or prove to us that these records are in fact disclosable, that is something that I don't see. Now, frankly, these are your records. These are your personal records. These are not like somebody else asking for your personnel records. These pertain to you. So the question, that's a different issue. That is something that needs to be taken up between you and the police department. And I don't know. I mean, maybe the civil service folks, maybe they get involved, or labor unions, they get involved because of contracts and collective bargaining. I don't know what the rules are in that, and any of that applies. But it's right now, for what's in front of us, I'm not quite seeing a path forward beyond what we've discussed today.
I appreciate your explanation. Thank you.
Okay, so I'd like to make a motion.
Yes, please.
I move that we refer this back to the Sunshine Ordinance Task Force with our findings that the recordings of the closed sessions exist, and that while some of them have been produced to the petitioner, some of them remain withheld upon general public disclosure under 67.8.1, under the justification of should I get this right?
832.7
of the, which code is that? Evidence, is that the evidence code? Of the penal code.
Yeah.
and that we make no judgment except to report these findings.
I will.
Do we have a
that
second?
motion.
Okay. So seconded by Member Wong. I'd like to open this up to public comment for members of the public who are not party to this case. Do we have any members of the public wishing to make comment at this time?
Anonymous, please.
Okay, hold on one second. Cheryl, are you ready with the timer?
Yes, I am. Go
Thank
ahead,
you very
Anonymous.
So there's a number of different issues here. First, I can't find a citation to 832.7 in the original written response to the records request. Maybe it's there, but I can't find it. And if there wasn't there in the original, response to Mr. Ford, that is a 6727 violation. Second, the respondent mistakenly stated, oh, well, this is not a public record, it's a personnel record. As the chair has now stated many times, that's not the definition of a public record. Everything in the possession of the government that is about the conduct of public business is a public record. There's a court case, San Gabriel Tribune versus Superior Court 1983, which says that. It's also in the CPRA. Yes, it may be exempt from disclosure, but it is absolutely a public record. It doesn't matter how it got there, why it got there. It doesn't matter. And they've made that many times. City respondents make this mistake. Finally, it is possible, although this is not legal advice to the complainant, that it may be the case that it's disclosable under Penal Code 832.7 832.7 B1A2, and the reason is because I just read what the police commission did. They claim that he caused serious bodily injury. I don't know if hitting someone with your car is considered a use of force that results in great bodily injury. Maybe, maybe not. Maybe it's something for the full task force to consider. But it may be disclosable under the exception to the exemption 832.7 B1A2. And that is all I have to say. Thank you.
Are there any other members of the public? Yes. Are you wishing to make public comment? Hello?
Yes, please, also here.
I do, yes.
I'm hearing two people. I heard a woman's voice first. Cheryl, when you're ready, if you could give the timer, and then the second speaker who I heard after that.
Thank you, and thank you for letting me go first. And sorry, go ahead. Can you hear me?
Yes.
Okay. And thank you, Chairperson, for letting me go first and acknowledging that I'm a woman, because I've sat here for the last hour and a half listening to the men mansplain about this, and I don't know if this is what goes on in city government. It's just frustrating. Anyway, I don't understand what's so difficult. It seems to me that you talk about admin codes and penal codes and things like that, but if the sergeant is saying he can't release it, then he can't release it. Thank you.
Thank you. Is the next speaker ready?
If that's me, I am ready.
Okay, Cheryl, please give us when you're ready.
Go ahead, Mr. Warfield.
Yes, again, it's Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com. Also at P.O. Box 170544, San Francisco, California 94117. We're not a party to this complaint and don't know very much about it except what we have heard, and even that's been partial due to some technical difficulties. So I would say that I hope that the task force members, the committee members, are taking into account all that has gone forward, including public comment. I certainly agree with Anonymous on a number of points, particularly with respect to sometimes difficult to grasp for a lot of people, the difference between something that's a public record and something that is disclosable or non-disclosable. And yes, pretty much anything that's been created by a government agency or held or received by a government agency, anything in their possession is a public record. Whether it's disclosable or not is what largely the Sunshine Task Force and other jurisdictions have to say something about. The complainant made a mention of transparency, and he also referred to questioning whether the respondent's representative was knowledgeable, basically knowledgeable enough to speak with authority. Now, the law requires that an authorized representative come from basically the respondent's side. And the Sunshine Task Force rules require a knowledgeable person. But I think that in general, the Sunshine Task Force should often very much look at who is being sent and how knowledgeable they are, how familiar they are, and whether, in fact, they are a primary party involved in the whole business. And that's sometimes not so easy, but certainly easier when we find repeated violators coming with people who are very unfamiliar and have a lot of answers. I have no idea, I don't know, it wasn't me, and so on and so forth. I'm not saying that's this case, but I'm just saying something to be considered. And the other thing is that...
30 seconds, sir.
Thank you. Another thing was mentioned, the DCA, Deputy City Attorney, is available for help to the task force, and certainly it's true that they're always available for the city agencies to help them. And I think that it's unfortunate and it needs to be taken into account, and maybe the Sunshine Task Force should do something about the fact that there is no deputy city attorney, or any attorney for that matter, who is there in place to help the public.
Your time is up, sir.
Thank you. Are there any other members of the public wishing to make comment on this matter? Members of the public not otherwise involved in this case?
Yes.
Yes.
I'm anonymous.
Okay, hold on. I heard anonymous first. One moment. Cheryl will give you the timer, and then I heard another voice after that. You will be next.
Go ahead, anonymous.
Yes, after hearing some of the comments relevant to this Sergeant Youngblood changing his mind very often, after reading some of the packet information, even to me, it's more than changes his mind. It's outright misrepresenting the truth or lying. Relevant to the case where Mr. Coors had asked for the records to be furnished as public records up front. Sergeant Youngblood said, no, that's not the case at all. I think also the packet relevant to the last meeting, Sergeant Youngblood stated Mr. Coors had a pending lawsuit against the police department. That wasn't true. There was numerous occasions it wasn't changing the story. It was not telling the truth. I strongly think that the team should look into having people such as Sergeant Ware, the secretary of the police commission, or Ashley Worsham, an attorney present at the meeting. I don't even know if it's feasible, but this court reporter that was engaged by the police commission, Anna Greenlee, I think they should talk to her. Those are all people that were present there and have a straightforward idea of what was happening. I clearly don't understand as a layman the logic and why Sergeant Youngblood does not want to release that information. It just makes me seem like he's trying to hide something. I don't know that, but those are pretty much my comments. And team, I really appreciate you giving me the opportunity to speak. Thank you very much.
Thank you for your comment. The next speaker in line, if you could wait, and Cheryl will let you know when the timer's ready.
Okay. This is Dennis Odessa.
Go ahead, Mr. Tedeschi.
Hi, this is Vincent. That's again. I've had my own experience with this type of with this type of issue in file number 18010. In that file number, I had filed a complaint against the chief investigator, George Cochran of the city attorney's office, giving my personal revocation, 5-year revocation ban from SFMTA, him acting as an agent on from SFMTA for a revocation that had a appeal hearing. This was an administrative hearing. This was a closed session. I said that closed session should have been private. It should have been it should have had confidentiality protections against that. Instead, what the chief investigator did was he handed that information, which had the information regarding that closed session, to my housing coordinator, who then disseminated it to the public. That was a violation under the Sunshine Task Force. The city attorney's office comes back and says, no, those were only public records. They were disclosable. Sunshine Task Force has no jurisdiction under this particular complaint, when they fully did. My experience has shown that any member of the public should never complain to the DPA or the OCC, whatever they're called now, regarding police officer misconduct. Why? Because that, as soon as you file that complaint, that investigation is closed. It's sealed. You can't even get your own. If they do come up with a final decision regarding your complaint, you can't even get that complaint. You can't get that complaint fully
30 seconds,
fully
sir.
heard. So again, it goes back to the transparency, the willingness of the Sunshine Task Force to keep things open to the public and for complainants. This seems like a willful way of hiding information from this complainant. Although Mr. Kors is a
Your time is up, Mr. Tedeschi.
Thank you.
Thank you. Do we have any other members of the public wishing to make comment on this matter? Okay, hearing none. Anyone? If you're not speaking, okay, everyone is on mute. Members, any further discussion, or shall we take our vote?
I have something to add.
Please go ahead.
As was sitting here listening to public comment, which is meant to provide us with different perspectives that could change an outcome in a motion. I do want to challenge Member Wong on the reading of 832.7, because while A exists, B also exists. And B also concerns itself with the same records as A. And it provides for the disclosure of those records under very certain conditions. One of the things we don't know about this case is the details of the case. So B, in order for the task force to be able to even consider B, as one of the public commenters had suggested, we'd have to know the merits of the hearing that was held in closed session, and or the details surrounding the issues related to the records that are being sought. Okay, that would mean diving into this a little bit deeper. Now, we cannot compel necessarily. We can and cannot compel that information. We can compel it because, as we've heard even in previous cases, you can't just make a blanket justification. The task force does not stand for blanket justifications when it comes to specific records that are being held. Okay? So the fact that this is a personnel record, and when you're looking and the now I will say also sitting here, I went back and I looked at the minutes of October 7th, and I went through my notes. I didn't take that very good notes of that hearing. I would now have to go back to the recordings, but I don't see a reference to 832.7. And so now I'm a little curious, having not, I'd have to go back to the previous Complaints and Amendments Committee hearing to see if it was brought up there, that where we heard this case before. So again, the task force will not stand for subsequent justifications beyond what was given to the requester at the time of withholding, of providing a justification for withholding. That is the complaint. The complaint is that whatever the respondent had told them at the time that they said, we're not going to give you, or we're withholding the information. If they subsequently bring up a different reason, okay, and that wasn't the reason that they gave them ahead of time, that could be, the task force could find a violation in that. That said, if 832.7A existed and only existed, and B et sequitur did not exist, then I think things are pretty clean cut at that point. The findings would be clear. I think that the findings go beyond it, because B provides a caveat for the records to be released, notwithstanding subdivision A. So
Mansplaining.
Please mute yourself, ma'am. You're disrupting the meeting, please. Thank you. So that is that is our work. That is the work of the task force to be able to discern these items, because if we're able to discern that the detail of the content of the recording is applicable under B, then it would be disclosable. So I'll stop there. I think we ought to amend the motion by adding an additional finding that 832.7B may apply if there was a disclosure by either party as to what the nature of the information is. Now, I'll just stop there because they don't have to do it. Either party doesn't have to do it, and they're going to then have to take it to a different venue at that point.
Well, and based on what you said, even if it is possible that we might find a violation for, and forgive me, I don't have the citation off the top of my head, but for not giving the appropriate reason in the initial response. But even if we were to find a violation for that, it would not necessarily mean that they had to release the recording of the meeting, because that still might be allowed to be withheld under 832.7. You'd think I'd have it memorized at this point. Mm-hmm. So it's possible we might find a violation and still not be able to compel the release of the audio.
That's right. That's true. I think there are many different ways this can go, but I think it's important to add to our motion that 832.7b is also applicable if the merits and or the detail of the closed session was all about, so that it could be, so that we can determine whether 832.7 is a proper justification. We don't know if it's a proper justification or not, because subparagraph B provides us with latitude.
For clarity, would you like to restate what the current version of the motion is?
Okay, the motion is to recommend to refer to the sunshine. Hold on, Cheryl, can you read back?
I was going to say, yeah.
Go ahead.
Okay. Member Wolf moved to refer the matter back to the Sunshine Task Force with our findings that the recording of the closed sessions exists, and that while some of them have been produced to the petitioner, some of them remain withheld upon general public disclosure under 67.8-1 under the justification of Penal Code section 837. And that we make no judgment except to report these findings. And that's where I left it off.
Okay.
Because then you started talking about 832.7b.
Okay. So
I want that language.
Okay. So I'm going to pick up on the part of under the justification of 832.7 A, which the respondent is upholding as justification for withholding the records, and that the task force should consider 832.7b as a test if A actually applies, period.
You did bring up the subject of 832.7 may apply if the merits and the details of the closed sessions, of what the closed sessions are about. Does that make sense?
I'm sorry, repeat that.
I had left off at 832.7 may apply if the merits and the details of what the closed session was about.
Right.
Do you want to restructure that?
Does it sound not correct?
No, I'm just asking if you would like to say it that way, or is there something you want to add?
Well, I think the only thing I would add is that is not clear that 832.7 was used as justification at the time of the original hearing as for withholding. That's another finding. And and again, that has to be, I would say it's more not a finding, but the task force should review whether 832.7 was a justification used at the original hearing by the respondent.
The original hearing being the task force hearing?
Yes.
Okay.
So,
let's just get this right. I want to make sure I got this right. This is Penal Code 837. Okay. Let me read it back so that we can decide if we want to change anything.
Okay, go ahead.
Okay. Member Wolf moved that the matter be referred back to the Sunshine Task Force with our findings that the recordings of the closed sessions exist. While some of them have been produced to the petitioner, some of them remain withheld upon general public disclosure of, that's Admin Code 67.8-1, under the justification of Penal Code 837. And we make no judgment except to report these findings under the justification of Penal Code 832.7a, which the respondent is upholding as justification or withholding the records, and that the task force should consider Penal Code 832.7b as a test if A actually applies. Penal Code 832.7 was used as justification, and the task force should review whether 832.7 was justification used at the task force hearing, at the first task force hearing, is what we want to say, right?
Right. Let's go back. Let's go back to the sentence of 67.8-1, and add. Let's see.
Do you want me to read it again?
Yeah. Can you read that one again?
Okay. Move that the committee refer back to the task force with our findings that the recordings of the closed sessions exist, and that while some of them have been produced to the petitioner, some of them remain withheld upon general public disclosure under Administrative Code 67.8-1 under the justification of Penal Code 837.
Okay, that needs to take out the that are withheld under 832.7. Okay, that take out the 67.8.1-1. That needs to be put somewhere else.
Okay.
That we find, I would add on to the end of that sentence that we also find that the records are public under 67.8-1.
Okay.
Because the context is that we do, this was held in a public hearing. There was a closed session. The closed session had to be applicable to 67.8-1. The fact that did happen and that the records do exist, then the question is can the records be disclosed? And the justification for withholding by the respondent is 832.7. And then we go on from there. So that's kind of the flow of this. Yeah, that's it. So
Okay.
that I would ask, our the seconder. I'd like to revise the motion to include all of this additional language. and ask the second if she is in agreement.
I am in agreement with the amendments, but I will also make a note that this is unrelated to the motion. But I want to make a note that I do have in my notes from October 7th a mention of Penal Code 832.7. So we may want to look at we may want to recommend to the full task force to take a look at those minutes as well.
Okay. I'll put out, as chair of the task force, I'll put out a regular note to folks or people just to generally prepare yourself for the day. So, yeah, no problem. Yeah.
So
I just have one thing to say. So Bruce, I have written all this stuff down. However, I'm going to send it to you in Word format. So if you take a look at it after reading it, we can just make sure that it's clear.
The way I presented it is the way it needs to be written. If there's any clarifications that need to be made, we'll do it when it's presented at the task force.
Okay. I was just going to say what I want to be clear out is the part of the motion that you wanted to remove, and then you added under the Justification Penal Code 837. We also find that the records are public under 67.8-1. So we want to remove the clause, some of them remain withheld upon general public disclosure under 67.8-1. Correct?
Correct.
Okay.
I mean, the only thing I will do is I will take whatever you send me, and I'm going to listen to this playback and make sure that it's correct.
Yeah, I agree.
Okay.
I agree with you.
Okay, we'll talk about that part later. Okay. This is the motion. I'm asking, so I'm ready to go.
Okay, so we have a motion. We have a second. We took extensive public comment, which influenced the modification of this. Do we need to take public comment again, or should we just take a vote?
I think it was a substantial change in
I think
the
we
motion.
need public comment.
Yeah.
Okay.
It was substantial.
So I would like to open this up for public comment. Public commenters, keep in mind that your comments did influence this version of this. So if you already said something, you know what? I'm going to let you say what you want to say. We're opening this up for public comment. When Cheryl is ready for the timer, she will let you know. Do we have any members of the public not associated with this case who would like to make public comment on this matter?
Yes, anonymous, please.
Okay. Before you start speaking, do we have other members of the public? I'd like to get people lined up if we can. Any other members of the public who'd like to make public comment on this? Okay. I'm going to take the one public comment. Cheryl, when you're ready with the timer, please give the signal.
Go ahead, Anonymous.
Thank you very much. I think there's a small tweak that needs to be made to your motion. So 6727, which is what you just discussed, does not require that they come to the first SOTF hearing and cite Penal Code 832.7. It requires that the original written response to the request before they filed a complaint contains the written justification of Penal Code 832.7. So I would urge you to change the motion to say, I think it was about investigating whether or not they said it at the first hearing. I don't believe that is the positive issue here. It's whether or not they cited it in writing to the requester at the time of the request before the person filed the complaint. After they filed the complaint, I'm sure they gave all sorts of justification, but I don't know if it was cited in writing at the time they responded to the request. Also, I believe there's, I don't know if you want to call it a typo or what, not, but sometimes somebody said 837. All of them are 832.7. There's no 837 relevant, I believe, to this case. Thank you.
Thank you. Do we have any other members of the public wishing to make comment on this matter?
Yes, please.
Okay. One moment. Cheryl will let you know when she's ready with the timer.
Go ahead, Mr. Warfield.
Yes, it's Peter Warfield, Executive Director of Library Users Association. I want to thank the chair, I guess it's the chair, trying to recognize voices, for offering public comment again, especially as she pointed out that there are some changes. I do want to just say that I had difficulty getting to make public comment because there seems to be a very long delay. I calculated about 4.5 seconds from when you push *6 to when you get a response saying you've been muted or unmuted. So it's very confusing. You push and nothing happens, and then you push again, and the whole thing is rather confusing. It's something that I hope you will take into account whenever you offer public comment to anybody, and also a chance to get back in the line if for some reason they've muted themselves when they were actually trying to unmute themselves. In any case, I've made my public comment as much as I can previously, and so have no position on the revision. Thanks very much.
Thank you. I don't believe there was any other public comment. I'm closing public comment. And Member Wolf, you had a response to make.
Yeah, just that was based upon the first public comment. That was an oversight on my part, because I did mention that early on tonight in this for this case, that the justification that was used is based upon the justification given to the requester at the time that they are withholding the records. It's not at the time that the complaint is heard by the task force. That is that's the complaint. The complaint is based upon the justification for withholding. The petitioner doesn't agree with the reason. So I think what we need to look at is whether 832.7 was the justification given to Mr. Coors by the police commission at the time Mr. Coors requested the records and was denied the records. That is the point of contention. If 832.7 popped up subsequently at the time that this was brought to the task force, that is not that's not an appropriate introduction for the justification. That's what the task force has been trying to avoid.
Okay, but I would say I don't think we need to modify the motion because,
we'll bring that. I'll make a note of that. I'll bring that up at the time this comes back. I mean, this is not a judgment. This motion,
right?
This motion is just to refer it back to the task force with findings, any new or additional findings or clarifications that we have learned about today that will help the task force come to a conclusion or determination of this particular case. Period.
Thank you. I think we're ready to call roll.
Member Wolf.
Aye.
Member Wolf, aye. Member Wong.
Aye.
Member Wong, aye. Chair LaHood.
Aye.
Chair LaHood, aye. I'll read the motion back. We have it on the record. Member Wolf moves that the matter referred back to the Sunshine Task Force with the committee's findings that the recordings of the closed sessions exist, and that while some of them have been produced to the petitioner under the justification of Penal Code 837, we also find that the records are public under Administrative Code 67.8-1, and we make no judgment except to report these findings under the justification of Penal Code 832.7a, which the respondent is upholding as justification for withholding the records, and that the task force should consider 832.7b as a test if A actually applies. Penal Code 832.7 was used as justification, and the task force should review whether 832.7 was a justification used at the first Sunshine Task Force hearing. Is that correct, Bruce?
There was an issue at the very beginning.
Yeah.
837 was read, but I think it should be 832.7.
Oh, you're right. Thank you.
Mm-hmm.
Okay. Thank you. I think we are ready for the next item.
Okay, hang on a second. Item number 7, file number 19140, complaint filed by Stephen Malloy against the Department of Human Resources for allegedly violating Administrative Code Section 6721 and 25 by failing to respond to a request for public records in a timely and or complete manner.
Thank you. Is the petitioner here?
Yes. Can you hear me?
Yes, we can hear you, Mr. Malloy. Thank you. Is the respondent or a representative here? Do we have a respondent from the Department of Human Resources?
Are they on mute?
I don't know. I'm going to give it a couple of seconds. Do we have a respondent here for this matter? I am not hearing anyone. And this is kind of a key point in this case. So we found an order of, we made an order of determination, and the reason this matter is before Compliance and Amendments again is for compliance, and one of the key issues in our order of determination was that the department did not send a representative to our full task force hearing. And we found a violation for that, and also because they did not keep withholding to a minimum, did not provide footnotes or citations for the redactions. Since we don't have a representative here, for the respondent, I'm a bit concerned, but I would like to ask Mr. Malloy, has the respondent complied with our order of determination in total or in part?
They have not responded or complied at all.
Okay. Members of the task force, what should we do about this? We're seeing a persistent non-response from this department by not sending anyone to our full task force hearing, not sending anyone to Compliance and Amendments. What do you propose that we should do about this?
It seems like a case that's worthy of escalation to me. And I believe, correct me if I'm wrong, the next step in escalation is referring this to the Ethics Committee. Is that correct?
That is definitely one of our options. We can also refer it to the Board of Supervisors. We can also refer it to District Attorney's Office. Member Wolf, would you like to add anything?
Yeah, no, those are pretty much the DA or the AG, but and we have been discussing whether we have the ability to send it over to Superior Court because they have jurisdiction over these things also. I think maybe at this point, I agree with Member Wong that it should be escalated, but that may be a communication be sent to the department head requesting their presence or demanding their presence.
Well, and in order to escalate, I think we need to send back to the full task force anyway. So perhaps our recommendation should be to send this back to the full task force, to send a letter to the department head compelling their appearance at that meeting with a warning that due to noncompliance, we are considering escalating this to other agencies.
Well, I would just say I wouldn't go that. I would let the task force make that determination.
That is appropriate. Yes. I'm trying to move.
I get it. No, I hear where you're going. I don't think that much detail is that needed. I think the point of escalation. I think that's all that really needs to be said.
Mm-hmm.
Is to compel the and that with a communication to the department head that if they don't appear, that this will be escalated. Period. I think that's less is more.
Okay. Would one of you like to make a motion on this? Go for it.
Okay, I'll make a motion to refer this back to the full task force with recommendation to how detailed do we want to get then? I guess with a recommendation for escalation due to both non-compliance and also the fact that there have been no representatives made available to us by the Department of Human Resources.
Do we have a second?
Second.
Okay, I would like to open this up for public comment.
Hang on.
Sure.
Hang on. I want to make sure I got the motion right.
Okay.
Member Wong moves to refer the matter back to the Sunshine Task Force with a recommendation for escalation due to both non-compliance with the order determination and that there have been no representatives available for an appearance before a hearing.
That sounds correct to me.
Okay. Thank you. Now we would like to open this up for public comment to members of the public who are not party to this case. Are there any members of the public who would like to make public comment on this matter?
Hello.
Hello? Did I hear someone who would like to make public comment?
Yes, I would like to make public comment to Anonymous.
Okay, Anonymous. Is there anyone else who would like to be second in line? Okay, hearing none. When Cheryl's ready with the timer, she will let you know when you may begin speaking. Thank you.
Anonymous?
Yes, may I begin?
Go ahead. Go ahead.
Thank you. This is Anonymous. I think that I assume the letter would be explicitly issued by the chair of this committee. I guess that's how it normally goes. And I would simply say that you can and should cite in your letter SF Administrative Code 67.21D and SF Administrative Code 67.34, which makes it official misconduct for a department head to willfully not comply with the Sunshine Ordinance. And maybe if you just cite those sections of the law, they'll take it seriously. But there's another part of 67.34 in this escalation process that I'm not sure, I mean, maybe I haven't been in enough task force meetings to hear it being discussed. The Ethics Commission only under 67.34 deals with alleged official misconduct via willful violation of department heads and maybe elected officials. But all other managerial city employees are required by 6734 to comply also with the Sunshine Ordinance, and there is no requirement to send their alleged official misconduct by willful violation to the Ethics Commission. So to me, if there is any person in the management chain other than the department head of DHR who is not properly responding to these requests or responding to the task force, I think the task force itself, without any escalation, has the authority to determine that that person, that city manager who is not a department head, committed official misconduct by a willful violation of the Sunshine Ordinance. And you should consider that at the full task force. Thank you.
Thank you for your comment. Is there any additional public comment? Seeing none. Members, any final comment on this before we take a vote?
And do I get to say something?
I am, that is not typically our process. Since
I thought everybody was saying something tonight.
Well, you know what, Mr. Malloy? I will give you a chance because I only gave you a chance to say one thing. You may make a brief comment on this matter. Go ahead.
Thank everybody for their work tonight and also for the folks calling in. Yes, I would ask that you add 6734 because it is willful and always has been that this department has specifically chosen to discharge its duties under the SOTF. And so I definitely would request that you make it willful because it is, and that also I would like it to go before the board, the city attorney, and the Ethics Commission. Thank you.
Thank you for your comment. At this point, this is a motion to refer it back to the task force, and the task force will determine the official course of action. Members, do we have any other comments to make at this time or any adjustments to the motion?
I just want to say that the public comment has been noted.
Thank you. Cheryl, if you could please call roll.
Member Wong?
Aye.
Member Wong, aye. Member Wolf?
Aye.
Member Wolf, aye. Chair LaHood?
Aye.
Chair LaHood, aye. The motion to refer back to the task force with recommendation for escalation due to both non-compliance and that there have been no representatives made available for appearance before SOTF hearings or task force hearings.
Thank you. Thanks everyone for your participation. Cheryl, I think we're ready for the next item.
Thank you.
Item number 8, file number 19114, complaint filed by Shane Andrews against Tyler Vu and the Public Defender's Office for allegedly violating Administrative Code Section 6724, 25, 26, 27, and 29 by failing to respond to an immediate disclosure request in a timely and/or complete manner.
Okay, is the petitioner here?
Yes, Shane Andrews here.
Okay, thank you, Mr. Andrews. And is the respondent here?
Yes, Tyler Vu for the Public Defender's Office.
Okay, thank you for both for being here this evening. We are here, this is for compliance. Mr. Andrews, can you give us an update on whether our order of determination has been complied with?
Yes, I would say it has not, in respect that as listed on the evening's agenda item, the Public Defender's Office, Mr. Vu, was instructed to either produce a record, unredacted, or in redacted form citing specific authority for the redaction. But instead, I received a letter explaining why all of the documents at issue were not public, and therefore he was not required to do either.
Okay, and Mr. Vu, can you explain why our order of determination was not complied with, and instead a letter explaining why the documents are not public documents?
Sure. I think before I do that, I would like maybe clarification from the task force as to whether or not Mr. Andrews' statement of the request for compliance is actually accurate. And I believe that at the last time we met on this particular matter, it was Member Wolf who phrased what we had to do to comply. And I don't want to misspeak in terms of what Member Wolf said had moved for us to comply with.
Which member Wolf? Because Josh Wolf was still on the task force.
Oh, it was you, Member Wolf.
Okay.
And if I mean, I can certainly state what I thought the issue was when we last left off, and I know that it's in the record. So I think that before I think that the statement of Mr. Andrews is not accurate. And so before I proceed, I'd like to get clarification as to what the task force thinks the issue was when we last left off. And I am more than happy to state what I thought it was, but I didn't want to speak for a part that I don't think came from me.
It's up to you, Madam Chair.
If you could give us one moment, I looked at this earlier today, but based on your question, I want to look at the notes one more time. So I guess this is the challenge is here is that we requested the documents be provided. In between our request for the documents to be provided or not even in between, we asked that the documents to be provided, and then the Public Defender's Office subsequently determined that some of those documents were not public and so did not need to be provided, and thus not redacted or citation for the redaction. Members, I'm not sure what we do at this point. Do we need to? It feels like this case has been with each hearing, it keeps getting whittled down and whittled down. Even when we request for things to be done, and typically those things are not done, and there is less to even respond to after each meeting. I mean, we were down to one email, either unredacted or with citations for the redaction.
I mean, I think that email should still be produced with the redaction citations, correct?
Yeah, I guess the question is the document public? And if it is public, unless there's some justification for it to be completely withheld, then the document should be produced redacted with the appropriate, key log for the noting the justifications for the redactions.
I'm recalling, actually, Mr. Vu, can you remind us, and I believe I remember, but I'd like to hear from you, why you believe that this particular email is not a public record?
Sure. I think where we last left off, the task force had in its review the items at page P1899, P1900, and P1901. So at that time, member Wolf looked at it at those three documents and saw the redactions contained in those three documents. And member Wolf then, I believe, went through a Q&A with me and asked me various aspects of this meeting. And in the course of that Q&A, member Wolf, I believe, asserted, and I think the rest of the task force agreed with member Wolf, was that essentially Mr. Andrews had gotten lucky, in the words of member Wolf, that in fact the Public Defender's Office had disclosed more than it should, and in fact the items that it disclosed, it did not have to disclose, and so therefore, even though it did make the disclosure and it did redact those items, it essentially basically had disclosed too much, and therefore, even though we failed at the time to not make a notation as to why it was redacted, there was essentially no error on our part. What remained at the time? So what remained at the time was that items page 1899, which is and page 1901, it was clear to the task force that those things were all concerning like a manager's meeting, and they were agenda-related items because the task force could see from the way that they were the subject matter that they were an agenda, and so therefore I believe that the decision was made that those items did not have to be turned over. When we left that hearing, the only item that remained outstanding was item number on page P1900, where it wasn't clear because of the subject matter, quote unquote, a few things, whether those items were actually pertaining to the formulation of an agenda. And so I was instructed at the conclusion of the last task force hearing to review the item number at page 1900 and to determine whether or not that particular document also pertained to the formulation of an agenda. And so I did do that, and on October the 30th, I wrote a letter to Mr. Andrews and CC'd the task force indicating that upon review, that email was also part of the formulation of an agenda in the same way that the email on page 1899 and 1901 was also a formulation of an agenda and did not have to be disclosed. That was my understanding of where we last left off.
That reflects my understanding as well. So at this point, Mr. Andrews, are you, is there anything outstanding that you have not received or have not been given an explanation for, or for which you think the explanation is not satisfactory?
Sure, to be frank, that would be all of my requests originally submitted over a year ago, because at each and every proceeding, this committee has allowed the Public Defender's Office to not only rewrite my request, but to rewrite the committee's specific instructions, not only when Mr. Vu was going to come back and produce documents in camera, it never did that, and that just got skipped, and then was told to produce some just very limited emails, and he hasn't done that. But you know, at this point, I see no point in arguing it. This committee has made clear it's not willing to force the Public Defender's Office or even recommend it do anything. Frankly, its response was untimely. It has not cooperated with the proceedings in any sense of the word, and I would request that it be referred to the Ethics Committee for that reason alone. I have another records request to which they've not responded to correctly, and I'm hesitant to come back before this committee once again, given what I've experienced with the Public Defender's Office's ability to rely on one Coronado case that's inapplicable to the requested issue, but clearly is enough for them to not have to produce documents or even detailed explanations as to why they're not producing them. They cite a case and they say it's somehow in this sphere of private representation, and that is, from what I have heard, the committee members say they are not in a position to do anything further in that regard, which I have now learned. But again, it's disappointing, and I don't think that the committee is taking advantage of the powers it does have and is allowing a very convoluted arguments and time-consuming arguments that are non-responsive just sort of grind this whole process into basically no response. So short answer, no, I don't think any of the requests have been complied with, but I understand that there's nothing further to be done here.
Thank you, Mr. Andres. I see that Member Wolf would like to respond.
So, Mr. Andrews, what powers do you think that we have to be able to compel the production of these records?
I really don't want to take up any more of my time or the committee's time. We've discussed this numerous times. The committee has the ability to at least require the Public Defender's Office to provide, and I won't use the word privilege log because it gets everybody freaked out for a reason I don't understand. It's not a unique document, and it's just a list of things that they don't want to produce and explanations why. But we never got a list of what they want to what they wouldn't produce. You never saw that, and as far as I can tell, the code does give you the ability to at least require them to. I don't have the specific citations. We've talked about them so many times. That the withholding should be limited. That when done so, that there should be specific keynotes or references or citations. But first and foremost, identify what it is that you're saying is not a public record, or that needs to be withheld under some claim of privilege. And at no point in any of the hearings that I have attended or in the dozens of hours I have spent in this process has that ever been done. Not once. I don't even know what is being withheld, and neither does this committee. So at the end, it was unfortunately, I think a very time-consuming and publicly unhelpful process. And this is not directed to any of the committee members. I should have prefaced by saying this. The amount of time that you volunteer and spend doing this is admirable. That I appreciate. What I don't understand is the either the unwillingness or the inability for the committee to take a next step, to do anything when an organization, when a government body like this simply shows up and basically it's just, delay, and a year and a half later, there was no real resolution, no explanation, certainly no production, and that's just a commentary, really. I don't expect anything else to be done, but nevertheless, I again do thank the individual committee members for their time. That'll be it.
Thank you.
Member Wong, you wanted to say something?
Yeah, I just wanted to ask Mr. Andrews with regards to the emails that are on P1899, 1900, and 1901. Did you receive justifications for those withholdings, like at all? Any information regarding that? Or
No. As I think I explained, it was the justification is that they're now not public records. And the idea that I got lucky because they produced records that weren't public documents is certainly just another mischaracterization. It's because they produced something that was non-responsive. I haven't gotten lucky once in these hearings. I never received a responsive document, despite the fact that, my client is aware of the existence of documents, responsive documents, and we will pursue it through other means necessarily. But even what I've gotten, we're arguing over, I think, as one committee member said, a single email. And my only point really in showing up this evening, I debated it because I just wanted to see if the Public Defender's Office would do the one thing it was finally instructed to do. And on the agenda, what it says, and it was posted before this evening, it specifically says what was supposed to have been done. It wasn't, but again, there's no repercussion, and so it is what it is.
So I mean, we're as was discussed in the last meeting. I think we had narrowed down the request to a handful of emails, but it was determined that those were all related to planning for a staff meeting, which is not considered a public document. And I don't think that there's much more that we can do at this point. Members, do you see any other? I mean, we've spent many months and a lot of time on this and a lot of hours, and I don't see anything else we can do at this point. Do you have any other thoughts on this? Member Wolf.
So I think the order that was presented. The order that was presented by the task force to Mr. Vu was to present the email.
There's someone who needs to mute because we're hearing extraneous sounds.
Was that the Mr. Vu was to present the email either unredacted or with a keyed log of the justifications for the redactions. Okay, what we have here on page 1900 is still a redacted document. So I have to ask Mr. Vu, why haven't you complied with what was being asked of you?
For the same reasons and the same logic that was laid out by you, Member Wolf, which is that you had said to me at our last hearing that document number page 1899 and document number 1901, that both of those items were in preparation for a meeting, and that therefore, basically, in your words, Mr. Andrews has just gotten lucky, and so the only thing that remained, Member Wolf, was document number 1900, in which you essentially said that if this document was also in preparation for a meeting, it also fell within the same logic as 1899 and 1901.
I know,
And
but
so
Mr. Vu, I am not the only one that sits on this task force. So taking what I say, if it's not part of the order of determination that is if people disagree with me and it comes out in an order of determination that they don't agree with my statements, what I have to say is you're taking out of context.
No, actually, they did agree with you. That was what you guys all agreed to when we last left. And so all that was remaining for me to do was to go back, look at the underlying document, and report back to everybody whether or not the last document, item number 1, was in fact in preparation for a hearing. I'm sorry, in preparation for a staff meeting. And in fact, I did do that, and I did write the logic and the reason behind it in my letter, both to you and to Mr. Andrews. I mean, I don't know. I'm actually a little bit concerned because Member Wolf, you led the last initiative on this, and I thought I was doing exactly what the task force told me to do at your leadership.
I'm just trying to find my I don't have that. Just want to reflect that in my notes. I'm sorry.
That was at the full task hearing.
But the full task force hearing, what matters in the full task force hearing is what is in the order of determination. But I hear what you're saying. I hear what you're saying. I'm sorry. I don't have my notes to provide me with the recollection of that, which makes things somewhat not right either.
So as far as I can tell, there was a motion made at the October 7th full task force meeting.
Right.
That passed. So that was a violation of section 6726 for not footnoting or giving clear reference to justification for not providing records.
Is that in the documents in the packet?
It's in the minutes. So I can add these to the chat. So that is the full task force. And then
in my preparation for this, that's probably why I'm having a blank. Okay.
And then the part of the motion was to refer the matter to our committee, and then our committee meeting, our last meeting in October, not our last meeting, but a meeting in October as well, October 27th. There were no actions taken, but Chair LaHood requested that Mr. Vu present the email either unredacted or with citations for the redactions.
Right.
For 6726 by the end of the week. And that is what we are expecting.
Right. That's exactly what I'm referring to here.
But then he sent us an email saying this email, like the other ones, is not a public document because it was in preparation for a staff meeting.
I get that, but that's beyond the point here. I mean, ultimately, what really matters is what happened at the very end of that meeting, which was Chair LaHood requested that Mr. Vu present the email either unredacted or with citations for the redaction as per 6726 by the end of the week.
Right, but if his assertion is that it's not a public record, if it's not a public record, does he have to do that?
Yeah, but we're beyond that because the task force already declared it to be a public record.
But he came back and said it wasn't a public record.
Doesn't matter. I don't care. Doesn't matter. It's a matter of what the task force has made a determination of.
So if we made a determination for similar documents and said those weren't public records, it doesn't matter that this one is like those because we did not say it was, and so he needs to give us the information even though it might not be a public record.
I think that was what was understood at the time, and why that at the end you made the assertion that you did.
That is why I made the assertion
right.
that I did.
Right.
But if he comes back and says, "Oh, sorry, it was for planning a staff meeting, so it is in line with these other documents that we did not, that I don't need to," please, Member Wong, go ahead.
Well, prove it.
I feel like this is very similar to the last file that we just heard, but what matters is the response, their original response to the request. The original response to the request were these documents, but they were missing the citations, which is what we found the violation for. And so I don't think that a respondent can follow up and say, "Oh, actually, I shouldn't have released these," because they're already released. The problem was that they were missing the citation. So now the citation, we found a violation that the citation is missing, and so now the citation needs to be referenced. So it's like you have to go back in time and say what you were thinking back then.
So here's the problem. We've already found, we made an order of determination. We found a violation. We said that compliance was required. Compliance has been minimized and minimized and minimized to a point where there's nothing left to be done. Technically, could we recommend a finding of another violation? I guess we could, because as you say, this justification was not given at the very beginning. But I don't know that that does any good or satisfies any of what the petitioner wants. I'm a little bit baffled at this point. But I mean, we could send it back to the task force and make a recommendation for another. Would we even make a second order of determination on the same issue? Isn't it all about compliance? But if there's nothing left to comply with, what do we do?
Well, no, the point is if the task force made an order of determination.
Yep.
The purpose of this committee is to assure that compliance, or to monitor that compliance has happened. Mm-hmm. If compliance has not happened, then we need to report back to the task force that compliance has not happened according to the order of the task force. I don't care what details have been laid out in that way. All that matters is what's happened at the end. In the end, there is an order of determination to produce documents. To try to adjudicate it after the fact, after the task force had already adjudicated those same documents, is something different. If any of the parties have concerns about the outcome of a hearing with an order of determination, there's an appeals process. It's called reconsideration. They have 30 days to file for it if they have enough compelling evidence to show that a reconsideration would potentially change the outcome. Okay? If the task force, even if the task force was completely wrong, it doesn't matter. Okay? What matters is that the task force made a decision through its order of determination, whether it was a unanimous vote or a split vote by majority rule, the order stands and is valid, and the party is to comply with it. And so that's really kind of where we're at. with this. I'm not going to. I don't think it's fair to re-adjudicate the case because now that the respondent has found a record and they determine that it is not a responsive record. The question then is, then prove it. But we've already determined, they've already been asked to produce the document. Okay, so if the page 1900 is that document, okay, they produced the document. Well, where's the rest of it? We want to see the key log and the justification for the redactions, because we already declared it as being public. If they don't agree with that determination, then file a reconsideration and appeal, like lawyers do, and do that. I would say don't just run roughshod over us, because you don't agree with our decision or our outcome. Okay, we're doing this from the position of what the public is based on the balance of what's in the public interest. And the public interest that the task force found after many days and hours is that this is a public record and it should be disclosed.
So you would like to send this back to the full task force with a finding that there was non-compliance with our order of determination?
I think that's the only thing that we can do at this point. They were given an order. I don't think it matters what I say in context. What matters is what the order determination requires. I mean, lots of things get said during a hearing. What matters, the rubber meets the road, is what's in the order determination.
So if we go back to the full task force, and then at the full task force level, Mr. Vu could then say, I know you found this to be a public document. It turns out it's not a public document, which is why I did not comply with the order of determination.
Then the task force would have to evaluate that. Okay. Now we can evaluate that and we can make a recommendation back to the task force. I'm not. That's why I put the question out there to say, prove it. Prove that this redacted page 1900 is work product and not a public document. Prove it. Just by saying it is not enough. Okay, I appreciate that. I appreciate that. Mr. Vu is an officer of the court, and I'm sure and that he holds the greatest, highest ethic for for the position and for the license that he holds. I'm sure that is the case, but I think as well as he knows, that we all know that the proof is in the pudding. Show us the proof. Okay. And
member.
Yes. Who's speaking?
Yes, this is Tyler Vu with the Public Defenders again, member
Yes.
Wolf. I think that I just want to quickly address your request that I approve it. And that is contained, and I think that was what you asked me to do when we last talked to each other on this particular topic, was to prove that page 1900 was in fact part of preparation for a meeting. And so in my letter to Mr. Andrews and to you as part of the task force on data October the 30th, at page P1910, I do lay out the proof that you requested me to do. In fact, it begins at the second to the last paragraph on page 1, where I say, at the committee's direction, the public defender has reviewed the remaining item 1, and confirms in this letter that for the same reasons why items 2 and 3 are not public records, item 1 is also not a public record. And then I go into the actual details of why I'm making the case. The contents document in item 1 were similar in nature to the contents documented in items number 2 and item number 3. Topics listed in all 3 items were discussed at the general manager's meeting referenced in the disclosure. Identical to item 2 and item 3, the purpose of item 1 was to discuss, quote unquote, a few things for the management meeting. Additionally, the proximity in time and the subject matter of all 3 items are also evidence that item 1 is related to the agenda preparation of a non-public meeting. The agenda preparation item 1 began with a few things at 8:56 a.m., followed by, quote unquote, a couple other management meeting items until an agenda formed at 3:24 p.m. with, quote unquote, agenda for tomorrow. As pointed out by the committee, although the documents were redacted, the public defender did not have a duty to provide any documents since they were not by definition public records. So you know, at the request of the task force, I tried to prove, based upon what I read from P1900, the quote unquote pudding, why P1900 is just exactly like P1899 and P1901, which this task force has already concluded at the last time we met that this was not a record that had to be released. I don't know what else I have failed to do that isn't consistent with what was requested by this task force. And I don't know what else I could lay out.
I guess the point is, Mr. Vu, that when I see a production of a document, okay, and it's redacted, and it's not being withheld, then I suppose there's some agreement that it's a public document, and that the appropriate measures that follow that should be taken. So,
but remember,
you know, I can't tell. This is why I wanted to have the closed session, so that we could, and the task force denied me of that. Okay, but this is why I wanted to have the closed session, to be able to determine, have a better determination, a closer determination of whether these documents are in fact a work product or not. And so, you know, that's kind of where it comes down to. I think it gets convoluted because because of that. You know, without being able to see the documents in camera or having some other way of knowledge of that these are in fact work product documents, there's no way for us to make a real solid decision. I think you can agree with that.
Actually, I don't agree with that, because the last time we spoke on this matter, you were the one who led a series of Q&A when you saw these 3 documents redacted. They immediately sparked your interest, and then you led a Q&A with me to determine if in fact these were actual documents that were public in nature, or if they were just simply in preparation for a hearing. And in the course of that Q&A, based upon the information that you were able to see, as in terms of the subject line for these 2 emails, you were pretty satisfied that these items didn't have to be disclosed, and that we had simply disclosed them in error, even though we did not make notations to the redaction. And the only task that remained left for me when I left the hearing was that 3rd document, page 1900, where it was not clear to you whether or not that document was also in preparation for a hearing. And so, I'm sorry, in preparation for a meeting. And so I reviewed it, and then what I did was I put my explanation and my research and my argument in the letter to you and to Mr. Andrews on October the 30th. Now that's my explanation. That is already laid out. That is my proof that I've laid out. And at this point, I am not sure what else I can do to demonstrate to you that the remaining document, the one document that's redacted, was also in preparation for a hearing. Now, if that's the case,
go ahead. I'm sorry.
No, it's okay. It's fine.
I guess we're hung up on page 1901, right?
No, we are hung up on page 1900. That is the only one that remains.
What about 1901?
1901, you were convinced that that was in preparation for a hearing because the subject matter was agenda for tomorrow. You were satisfied. I'm sorry.
Yeah. We were left with one email to consider because it was not clear what it was about, because there was only one line that wasn't redacted and it was about the article. And that's why it wasn't clear whether it was in preparation for the staff meeting.
I'm more than happy to review the transcript, audio transcript, and if I have to type it out myself, I will. I'm going
to review it.
Well, actually,
I'm going to review it myself because I want to make sure that what you're saying is accurate. I believe you, but I want to double check for myself. I'm not sure about page 1901. But the others, I would be in agreement with you.
Member Wolf, I mean, the subject line for 1901 is agenda for tomorrow.
Right, that's an agenda. Here's our agenda for everyone.
In preparation for a staff meeting.
Right. Okay, I'm done. I don't want to belabor this at this point.
So I have a fairly strong recollection that at the end of our last meeting that we had determined that all but one of the emails that all but one of the emails seemed to be related to planning for a staff meeting that only included staff members, city employees, and thus would not be considered public records, even though they had been previously released. So they had been previously released, but because they were not public records, we could not compel the citation and of the redactions on those, because even though we previously thought they were public records, we later determined that they weren't. We were left with the one email, which Mr. Vu, in his letter dated October 30th, came back with the same justification that this one was also not a public record. At this point, I think the only thing we're left to do is I guess because we're just a committee, we can't close this out ourselves. Or since this was for compliance, and at this point, if there is nothing left to comply with, or we feel as though compliance didn't happen because the response we requested didn't happen, although justification for why it didn't happen was presented to us within the time we requested. But if you think this needs to go back to the full task force, we can send it. Sure. Member Wolf, go ahead. Oh, you're on mute. You're on mute.
I think I just figured out what's going on here. The way the minutes are written, it's not clear as to what the flow of the meeting was about. I just want to read back the part that makes sense for all of this. Mm-hmm. And I'll preface it by saying that the context of this was a discussion as to whether the meeting for which the agenda was created, whether that meeting was a public meeting or not, whether that agenda and any of the documents leading up to its creation were public or not. So I'll read this verbatim, It says, Member Wolf noted that this is not a policy body. The staff meeting is not a policy body because it's not a board. It is not the Board of Supervisors, nor was it enumerated in the charter. This meeting is not an advisory board or commission, and is also not a standing committee of a policy body. Member Wolf opined that if it is a staff meeting, then no records are public with regards to staff meetings. Member Wolf also noted that it may be an advisory committee that was created by a department head. However, if it is a committee that is solely of employees, then it is not a policy body. So that is what led me to the conclusion that these particular records are not public, because they're information pertaining to a body that's not a public body. Okay.
Correct.
You know, I mean, you know, and it's a work product. So that's kind of that's where that stands. I think what I wasn't hearing from Mr. Vu in his argument back to me was that that we had determined that this was a staff meeting, and that's what kind of threw me off. And because I'm reading back all my notes and I'm reading through the minutes, it didn't necessarily specify that until you get to the kind of the middle of the paragraph. So I apologize for that. My oversight in reading back these notes. So yeah, I'll just that's all I had to say.
Okay, so at this point, the question is, do we wrap things up here, or do we need to send it back to the full task force?
This was the committee. Just trying to see what our charge was for this. Did we have a charge for this? Let's see.
It was for compliance, because we had an order.
Okay. So I think no, we can wrap it up here and then report back to the task force that it's that we found everything, that we found it to we either found compliance or we found no further. We just present our findings that the additional documents were
determined not to be public documents.
Determined not to be public either.
Yeah. So at this point, since I don't think there are any further documents for us to deal with, we already made we made an order of determination. And in fact, our order of determination included, the failing to respond to a request for public records in a timely manner, which I think, it's the order still stands, but there is no further compliance to be made based on what the initial request was. Do we want to have a motion to, I guess, close compliance on this case, or what should the motion be?
I guess. Yeah. I mean, I think that's, we just want to, stop the clock.
Yeah.
Do that.
So I tend not to make the motions because I'm directing traffic. Does one of you want to make a motion on this, or shall I make a motion?
You can make a motion. You're free to do so.
I will make a motion that we and following compliance on this case, seeing no additional documents to pursue based on the initial request. Do I have a second?
I'll second it.
Okay. I'd like to open this up for public comment. We would like to invite public comment from members of the public who are not directly involved with this case. Are there any members of the public who would like to make public comment?
I'd like to make a public comment.
Okay, I'm hearing two. I heard the first person who said I would like to make a public comment. We'll have you first. I heard a second voice. Is there anyone else who'd like to make public comment?
I'd also like to make public comment.
Okay, I heard a third voice. I think you know the order in which you will be speaking. Wait for Cheryl to let you know when she's ready to start the clock. Cheryl, will you let us know when you're ready?
Sorry, I didn't realize I was mute. Let me reset this. The speaker can go ahead.
Yes, hi, my name is Thomas Osley. I was the one that initially initiated the demand for documents from the Public Defender's Office. There's a few points I'd like to make. One is that I reported the Public Defender's Office for misconduct in a case where Matt Soderosen and Sangeeta Sinha did not communicate settlement offers to a client. That wound up being reported on in the Chronicle. After that article was published, several public defenders began to retaliate against me. I heard reports from court staff, including sheriffs and clerks, about things that were being said about me. And my request, my document request, was to try and get those same things that were being said, which were also being texted and emailed. I've seen at least one email from the Public Defender's Office to my office when I was working there, asking that I be demoted and reassigned. And so there are responsive documents. It had nothing to do with anything having to do with a client's case. And I've basically listened for a year while my request was misinterpreted, misconstrued, and there are responsive documents that I know exist, that I have seen, that the Public Defender's Office is, I assume, just going to argue are not public, which there's no privilege for. I'll give one quick example.
You know, Mr. Osley, I believe public comment is for people who are not party to this matter, and you're party to this matter. I apologize, but public comment is not meant for. And I know Mr. Andrews has been representing you, but this is for members of the public who are not part of the case.
Okay. I'm
so sorry.
No, do you want to strike my comments then from the record, or should we leave them there?
No, we'll leave it there. And I'm sorry, because I let you start speaking, and I realized that that we shouldn't allow that at this point. I apologize.
What would the procedure have been? Should I have been called as a witness during the hearing?
Yes.
Yes.
Okay. No problem. It doesn't matter either way. I just wanted to kind of clarify things because I thought things were really going off the rails the last few hearings.
Yeah.
Okay.
So just so you know, at the regular hearing, we call for any persons or witnesses to provide any facts or evidence on behalf of each party, and that's the time that folks are usually step up for that.
Okay. Well, can I at least thank you guys for all your hard work that you've put on over the last year and change, because I really do appreciate it. I know you guys volunteered. It's a lot of work, and it's late tonight, and I really do appreciate all you've done on it.
We appreciate the notion. Thank you.
Thank you. Thank you. And Cheryl, if you'd call the second speaker, please.
Okay. Please let me know when I may begin.
Go ahead, Anonymous.
Thank you. I believe this committee is completely wrong on the law in this matter. There were 21 redactions that were made. You issued a second order of determination. There are two orders of determination in this case. One in, I think, February of 2020, a second one in October. For some reason, the case only has the first order of determination, but you found two separate sets of violations It is not the case that documents in preparation for a private staff meeting are not public records. This is an incorrect statement of the law, and I would urge you to talk to your deputy city attorneys. Every single thing in the possession of the government that is not purely personal is a public record. Citation San Gabriel Tribune versus Superior Court 1983. This is just wrong. Now, it may be the case that they are exempt under a citation of law, but in preparation for a staff meeting is not a citation to law. It's possible that they're exempt under a California Code of Civil Procedure 2018.010, but that is only for attorney work products. So, for example, if those sentences reflect attorneys' opinions or impressions about the law, they are exempt. They're still public records. So they're public records, and they can be redacted under California Code of Civil Procedure 2018.010. But it is completely wrong that documents, emails, agendas, minutes about private staff meetings are not public records. They 100% are about public records. And I guess I'm going to have to request these records and make my own legal argument separately. This is wrong. Thank you very much.
The third speaker, please.
Hang on.
Yeah, may I start?
Nope.
Okay, so somebody will let me know when I can
Yes,
start.
go ahead. You can start.
Okay. Yeah, so I'd like to agree with the anonymous commenter before me that this is really problematic. The notion that the public defender's office can just decide on its own what is public versus what isn't public. Why even bother having a Sunshine Ordinance Task Force then? Why, if the Sunshine Ordinance Task Force is going to say, well, if you want to do anything further, you're going to have to go to a real court, then why, spend taxpayer money on having a Sunshine Ordinance Task Force? It just seems like a waste of time and money. And honestly, to be cynical, it seems like a way of making people think that their government is more transparent than it actually is. So yeah, I find this very problematic. Yeah, I would really like to see the Sunshine Ordinance Task Force, at least enforce what it can do with some more teeth. Thank you.
Thank you. We heard from our three public commenters. I'm going to make one last call. Hello?
Yes, this is Dentist Tedessa.
Okay, one moment. Wait for Cheryl to let you know when she's ready with the timer.
Thank you.
Go ahead, Mr. Tedessi.
Hi, Sunshine Task Force. Thank you again. The experience I've had, again, through my experience with the Sunshine Task Force, and this is not directed at you members individually at all. I do thank you for your time and your considerations, and I've actually listened to the hearings, the past hearings of mine, and I know that you're doing your best. But the fact that these different departments here in San Francisco can use the law and use citations while then turning around on a dime and then using them against complainants coming before you is just wrong. And that's why you are there to protect. You are there for us, the public. The public is coming to you. You should actually, almost give us, those who come forward, more of a chance, if you will, than the regular public. Because if someone's coming to you, filing a complaint, they must feel somewhat really passionately and really think that they have something there. they're not going to waste their time and filing complaints and all this to a commission just for fun. You ought to take the public's complaints seriously, and I know you do. But there are things that come in between the public and yourselves that are used to delay and to frustrate the whole process. And I hope going forward that it improves, because it's just gone downhill as far as I am concerned. Thank you.
Thank you. Last call for public comment from members of the public who are not party to this case. Okay, seeing none. Members, any final discussion on this? No. Yeah. Well, we're. I don't know. I want to say we do take this seriously, and we invest a lot of time and energy in this, but there are limitations to what we are able to do. Cheryl, I guess call roll.
Member LaHood?
Aye.
Member LaHood, Chair LaHood, I apologize. Member Wolf?
Aye.
Member Wolf, aye. Member Wong?
Aye.
Member Wong, aye. The motion to end activity by the Compliance and Amendments Committee on this case, because there are no documents to pursue based on the initial request. Is that correct?
That is correct.
Okay.
Thank you, everyone. We appreciate you showing up for all of the hearings. Cheryl, please call the next item.
Item number 9, announcements, comments, questions, and future agenda items by members of the Compliance and Amendments Committee.
Members, do we have any comments or things to discuss or to put on future agenda? Nope. Hearing nothing, Cheryl, please call the next item.
Item number 10, adjournment. I have 9:45.
Okay. The meeting is adjourned. Thank you, everyone. We appreciate you being here.
I have a question about the previous motion to end compliance activity. Are we referring this back to the task force, or are we saying that you will report back to the task force?
I think we're saying that I will report back to the task force.
All right. I think I should put that in the motion. Do you? Should we amend the motion? I know we've gone on to the next subject.
I don't think we need to amend the motion. I think I just need to report back.
Okay.
Member Wolf, is there?
No, it's just report back.
Yeah.
You know,
Okay.
and yeah, it's a committee report actually. I think this whole evening should be put on the agenda as a committee report.
Okay. I do have a question. Did you want that to be at the February 3rd meeting?
It can be.
All right. I will put something on there.
Okay.
Okay. Are we all adjourned now? Because I'm going to turn off the recording.
Yes.
Yeah. Thank you, everyone.
Any discussion after anyway.